328, paragraph 34. The KID Act, my lord, paragraph 34. The KID Act 34 is on page 328. The KID.
That is an extract.
That is an extract.
From
That's what-
Nagabhushan.
Yeah, because the last paragraph is 33 of the judgment.
So no, I'm saying read 328, para 34.
That is
it's an
extract
extract
from
of the earlier judgment.
Nagabhushan.
Correct. And that refers to Girnar traders also. That's why I'm reading that. The KID Act is of course a self-contained code. Said Act is primarily a law regulating acquisition of land for public purpose and for payment of compensation. Acquisition of land under the said Act is not concerned solely with the purpose of land development of it. It has to cater to different situations which come within the expanded horizon of public purpose. Recently, the Constitution Bench of this court in Girnar Traders versus State of Maharashtra held of the Maharashtra regional of the world language on the parity of reasoning, provisions of section 24(2) of the new language making 11A applicable would obviously be not applicable, and we would like to judgment.
That is why Ramchand line will apply.
No,
See,
that
you
is the principle.
You forget the 1984 amendment to the Land Acquisition Act. Let us
Yeah.
go to the Land and forget the 1984 amendment.
On principle, I have no dispute.
What happens to delayed acquisitions
No, not
under the
principle-
normal land
No,
acquisition?
not principle, I have no dispute. But the argument that 2013 Act would apply, that not I have a little this one. Because then I can show, merely because General Clauses Act applies, if KID is a self-contained code and it has provisions for everything, and the benches have taken views, not one, not three the benches have taken. Girnar Traders in case of Maharashtra regional town planning, KIDB in case of this Anusuya Bai also, and the earlier judgments. And number two, not insofar as balancing of equity is concerned, shifting of the date, obviously they can't be put to gross injustice like what has happened in the present case. I am a beneficiary. I am showing I have taken all possible steps. Beyond Lord giving them letters, reminding them, filing petitions, finding please pass over. What is going to come through? When the constitutional court balance. Look, today when your lordships are taking a holistic view of the entire matter, say that injustice should not be done. It can't be, Lord, should not be done to him, and Lord, I should be made to suffer despite taking steps in law. Beyond this, I could not have taken any more steps, my Lord. When the land is allotted to me, I'm doing work on that. I can't even give back that land at this stage. So I would be put in a very precarious situation that for their default, somebody else pays. And Lord, that is surely not the law of the land. Therefore, when your lordships consider this, please consider this aspect of the matter also.
That is interstate between
You and the
Must
KID.
be having some arrangement
Tomorrow-
where there is.
If your lordships once hold, then they will say you pay. If I have to not suffer, then my things should be kept open that I will be able to discuss.
Must be having arbitration clause in the agreement.
But that your lordships know. I'm only saying when your lordships lay down the law, that it has to be compensated. Compensation by the defaulting party. If it is attributable to me, definitely yes. I failed to deposit. I don't. Here I have taken steps. What else not a party could do? Because party beyond this plot can't do anything. Beyond filing contempt against them. That please pass awards. Writ petitions. High Court issues directions. Do it within 6 months. You file applications after applications to 3 and 11 to 19. Surely there is nothing.
No, see, right now, any compensation will be paid by the state
KID,
only.
by the state.
They'll ask me to pay.
That is when they ask you, you have to take your
I
appropriate.
can't. Thereafter, the defense and arbitration.
Of course.
Lord, what I'm saying is there are two ways. One is either your lordships today protect me fully, or the other way is that tomorrow when they fasten it on me, when I raise it before arbitration also, that's it, to protect my rights. That's right. My rights should be protected.
Turn the liability on them.
Lord, and your lordship will say
And,
that.
and then, if they ask from you, at that time you may pursue your remedies available.
So
Why should they be deprived of it?
I'm not saying they be deprived. I never said that, Lord, they be deprived. They should be compensated, there is no doubt. But what I'm saying is, it should not be attributed to me.
Yes, we'll clarify that. That you have taken the steps as both you as well as they have taken the step.
Lord,
They-
to
they
them,
have-
I have taken this.
No, they have also gone to the courts earlier.
Later. They went challenging. But they went challenging.
And their alternate also prayers were there.
2009.
2009 I have been in litigation. I have been running from pillar to post, my lord. These 35 petitioners, their representations for alternate sides.
So they would, from 2009, they have also been taking steps, you have also been taking steps. It is only they who are sitting
Absolutely.
in a deep slumber.
So in these circumstances, Lord, I should be protected. My rights should be protected.
Lordships are well in land acquisition matters, financial burden can't be pleaded, my lords, against the landowners, my lord.
What did we say?
Yes, my lords. I am very grateful, my lords.
What were you saying? Were we saying something different?
No, I am only saying because it was being argued so
No,
strenuously.
but he is also right in saying that he also cannot be penalized. If the state doesn't take action if the KID sits idle, he is only seeking protection of his interest. Now, what interest we can protect yours? It is you who is the culprit. Have you given to them? Are you willing to give them alternate piece of land now? Are you willing to give them equivalent pieces of land? You take instruction.
Framework is between who and who? Project proponent, nice.
That is what Mr. Chandrachud already read, that they requested you, if you are not in a position to give compensation, give us alternate site of land. We are aware about that, but are you willing to give? Come at 2 o'clock.
Lords, there are 11 acres of land under this award. I am doubtful, my lords, they will give alternate site in the Bangalore city, my lords. 11 acres of land. This will be a futile exercise, my lords, after arguing so long, my lords.
We are not shunting of the matter. We are only asking them to come by with instructions by 2 o'clock. No, sorry. Otherwise, we'll close the matter. No, not tomorrow morning also. No, we can't take the now new arrangement is today's matters won't go tomorrow.
Lord, this is Tuesday, Wednesday, Thursday.
No.
All right.
Tuesday fresh, Wednesday fresh, Thursday fresh.
And Lord, I thought the whole idea was to finish the NMDs with us.
New list every day.
I am appearing for the state.
But at least system.
In this, because I am appearing for the state and only regards, because with regard to the shifting of the date and why that power is not given to the state government of the SLO as a matter of policy, that part, and today, the petitioner's rights are kept open, which is what the observation in the single judge and the division bench. Yes, yes. No.
Absolutely. Entire power is with you.
The power of shifting of the date.
Shifting is only with you. Court is using its other constitutional powers to use it. Otherwise, you resigned an issue. That was the whole purpose. You can't peg the price on some day and prolong.
The reason why Manoj in Ramchand's judgment it says that it's not given to the state is Manoj, because only in exceptional circumstances under 226 and 32 Manoj, the court is empowered to shift the date.
No, that is not available to state. After 4,
and
6
it-
comes, 9 comes, 11 comes.
and
Once
Manoj-
they do that, 4 can't be.
And Manoj, for the other reason, Manoj, it will create havoc, Manoj, because imagine Manoj vesting the power into an authority, Manoj, with utmost discretion to shift the date. They are statutory bodies, Manoj, under KIDB, Manoj, they should not be vested with that power. So, Manoj, the exercise of whether the date should be shifted and who should bear the burden and to what extent it should be shifted, Manoj, is the exercise which has to be argued de novo, Manoj, again from the SLO up to the Honorable Supreme Court, which is
And then the matter should reach finality when
my lord,
in the next 25 years.
I have a short note to assist your lordship. There was, just to assist your lordship on this. I read a note, no counter was filed.
You are happening with the state.
Yes, Manoj. Just I'm only on the legal position because their interests should be fully protected and because the interests of my learned senior also should be fully protected and who is to bear, but to what extent that exercise has to be done on the basis of arguments. Who has caused the injury, etc. All those submissions.
That you may have, whatever remedies are available in law.
May I just give this for record, Manoj, for the court? Your lordship will also have the finding in the imputed order, para 9 and para 17.10. Both the findings in both those pages, note this exact proposition of law. Falling from Ramchand and the other judgment. 17.10, your lordship will only note at page 278 and paragraph 9 at page 17. Yes, Manoj. The state cannot do it, Manoj. That's the proposition which is noted, Manoj. That paragraph, your lordship will kindly have paragraph 9, Manoj. At page 16 it starts.
Page?
Page 16, Manoj, paragraph 9. Yeah. So that's the Honorable Division Bench's judgment, which affirms the learned single judgment. And this is a public project, Bengaluru to Mysuru project, which is a long corridor which was being built. And there were several stages at which this acquisition was challenged. So, sometimes at some stage, it should also be looked at whether it is their fault or their fault, or whether the court, interdiction by the court was also responsible, because it went up to 3 rounds of writ petition for filed in
Some share has to be.
So some share has to be.
No, I mean, that obviously caused the delay, because there was
So all those judges will have to be made as party respondents. Who are at some point.
May I just read paragraph 9 for your lordship?
Yes.
Further, the learned single judge held that the SLAO has to determine the compensation as on the date of issuing the preliminary notification as contemplated under Section 11 of the Land Acquisition Act and not to shift the date to a later subsequent date. The learned single judge has set aside the award passed by the SLAO and directed the SLAO to reconsider and pass the award. The grievance of the petitioner regarding shifting the date at any later date or subsequent could be considered only if the award is passed by the SLAO. The SLAO has yet to pass the award. The grievance raised by the petitioner in the writ appeal is premature. If the petitioner is dissatisfied with the award,
How is this finding correct in law?
the reason why, Manoj, because
The award was already passed. That was challenged by Mr. Nadkarni's client.
the award was challenged, it was set
By you
aside on
subsequently.
It
By
was
an
set
afterthought.
It was set aside on 4 grounds, 4 other grounds, not on the date.
So what will the SLA do on the date, Mr. Avishkar? Just tell me.
When the single judge directs that such and such date has to be taken into consideration, is the SLA left with any discretion?
Single judge then.
Competition, but pay the price at 2003.
Because then the date would be shifting. Because
Who should shift the date?
the Honorable
The
220.
single judge says that the date can't be shifted by SLAO. The High Court, the division may say that it is premature.
The reason why was because arguments possibly were canvassed at that stage. So if the interpretation on the shifting of the date.
You want us to be sent it back to the single judge?
I only said, this was a remand where the petitioner has succeeded today.
Remand?
The petitioner has succeeded and he's coming to
So remand what? Remand by directing everything to be taken away from them.
Principle is decided now, no?
Only respectful submission. They remanded back to the SLAO to pass the award, and in the event they were satisfied with the correct date as it was pegged by the SLAO, they could come to the Honorable Writ Court for the.
Whether the SLAO had a discretion to change the rate?
No, as per law, they do not.
No, as per law and after the judgment of the learned single judge.
As per after the judgment of the learned single judge, also no, because that.
Then then this finding that it is premature is wholly wrong.
Subsequent award which come onto this will be challenged again and then date
Yes.
could be shifted.
And
by
then they should wait till 2050. Okay, to see.
Passed.
So award is passed, then they should challenge it before the reference court. Then after reference court, they should go in the first appeal, then High Court, and then Supreme Court.
Have you paid the undisputed amount without prejudice? Have you paid nothing?
They have, I think, deposited in May 24, I think they've deposited to stop,
We have deposited.
to stop the interest. But that award is not binding on.
31 proceedings.
That's an award pursuant to a single judgment.
And then subsequently, the single judge set it aside. The Honorable Division Bench Melons has also affirmed the single judge's order.
Then there was another award.
Yeah. 6 crores inclusive of interest and all component remains.
Remains there. So at least to some extent,
So that we deposited immediately.
That was set aside.
No, the 2019 award.
That is set aside, no? That award has been set aside in any case.
yes, but the amount under that amount is
Amount.
amount under that award is already deposited.
After the impugned order, Mr. Natkani said there is an award.
So that brings it to 2 crore something from 56 crore.
Correct. Has that been deposited?
That has been, they have never issued
That's why
notice.
that's the old.
Old award. So that is gone. That is gone.
No,
No?
but that continues in deposit.
That
gone.
the foundation for that is gone.
Money remains with them.
The foundation.
Money remains.
I pray in those last 4 directions in my page 8 of my written submission. So otherwise, there will be great prejudice to him. There's only one prayer which I'm making. In 42, by sending the matter back, these submissions made by the other side, Manoj. Since 9, I've been in litigation for this one, 2009. After possession taken away in 5.
2019 to pay country. Direct award to be.
Say wrong statement.
I'm very grateful.
But any written submissions are required.
You can give it, don't make it too lengthy.
Just a small. I'm only asking for protection.
We are protecting, we are making it clear. We will fix up a date which meets the equities. We will say that the amount will be paid initially by the state. And if the state demands from you, then you will be entitled to raise all your grievances as you have raised in the equity.
Only on the notes on that equity from states, etc. What I have done, that I would.
That we have already noted,
All right, then we'll-
because that you are, to page 234, you have already raised that.
That's fine. My submission is-
If you want to give, you may give it in.
List of dates, comprehensive.
List of dates, Mr. Chandrajur's list of date is already comprehensive.
Obliged, grateful, very grateful.
Right, Krishna. I picked up the Police Welfare Confederation. In my respectful submission,
Service is incomplete in respect of item number 7, 7.1, 7.2, 7.3.
it's the 3C matter, where my docs have kept it 3C. 3C filter. The order of the NCLAT may have to be set aside and the matter may have to go to NCLT. The proceedings will have to continue.
No, the service is not complete insofar as some of the responses are concerned.
That comes in the office report, but since there are cross appeals, everybody has
Everybody
copies.
is here.
Although your lordship is right, the office report does seem to indicate that.
Your lordship had rightly directed, it is to be taken at the top of the board, Millard, because this matter have been here for long. And there are multiple appeals, Millard. I am appearing for the home buyers primarily.
The home buyers have.
And they are the directly
Matter will have to
affected
continue
parties.
Before NCLT.
My lords, in fact, last time, my lords,
Because the project is of 2011, we are in 2024, my lord. And nowhere the construction is happening
And
because
the
of
IRP is also here, my lord.
because of the problem, because of my lord, the joint venture between the two parties, my lord, 3C and
My lord,
Oris.
mine is the first appeal, my lord. I'll, if I may place it.
And we are affected.
my lords had asked last time.
And of course, to point out that there is, I prepared a chart also, there is a multiplicity of matters and the parties are common. And of course, the lordship takes it up, I'll share that chart. The lead matter, which seems to be the side that the Reliance senior on this side, where the officers arguing, which is the one of the welfare associations of the home buyers.
The Home Buyers
It's
Confederation.
called the confederation, we call this welfare confederation. Ultimately, what is going to come, just as an overview, is to see, lordship, three things. One is the IRP's reports which were made pursuant to him being appointed by the NCLT suo motu, pursuant to him giving all the NCLT's direction, verifying all the claims, putting them in three status reports, and those three status reports point out who are the creditors, verified claims, what is the modus operandi of this CIRP proceeding by the 3C group across several companies. Lordship, if I may point out, thereafter, Lordship, what I would show is how some of the arguments that are being taken have already been considered in dismissed appeals being foisted by the promoters or other related parties.
Let the-
Contempt against the RP in direct violation of the status order granted by the.
Yes.
Let the 3C group is gaming the system and Millet NCLT and NCLAT are being taken for a ride and the impugned order, Millet is clearly an order which needs to be set aside and the proceedings will have to continue before NCLT.
One sentence to add on that, till I need the status reports which show the complete true and picture about this collusive behavior of siphoning of funds, taking funds from the home buyers, siphoning it off, transferring it the assets to sister concerns, and then starting an IBC proceeding in which a client RB is put. Till then, there was no problem. After that, consistently, the arguments have been against the IRP, but no challenge to the status reports. Those have been duly considered, are lying there. If I have much to say,
Manoj,
when I have my.
I am for 850 home buyers, Manoj. I am the most affected. The status report is filed after the CIRP set
They are
aside.
colluding with 3C,
Manoj,
Nirmal Singh.
May I just speak? This status report is filed after the CIRP set aside as being fraudulent. Manoj, my lords had asked for a
What is
list
the
of
local railroad and appellate?
Manoj, may I just hand over the list of all the
That's also told the NCLT
Will
that
it
is
be-
sort of.
Your Lordship, I welcome the impugned order. Let impugned order cannot
heard in a
take time.
systematic way.
In this manner, can we start with the hearing of the matter?
Let the appellant should argue first, my lord.
Let it go, very humble suggestion, let it go sequentially, item
Yes.
7 first, 7.1 first.
Yes.
That perhaps is the only way, not otherwise everybody will be speaking over everybody else.
We agree.
But this is all the list of parties also, my lord. We made a list because it was very difficult to come to who will speak first, etc. So we made a list of parties also.
I also carried one.
How much is your,
According to me, the question of law is now decided in other, in the Byju's matter. Therefore, once the proceedings are in rem, without even hearing us, if the said proceedings have been set aside, surely that will have to be restored and the matter will have to be heard. If they want to move an application, so NCLT will have to consider it. The NCLT proceedings will have to be restored. NCLAT order is clearly contrary to the law laid down by my lords.
Unlike
The IRP
Byju's, this is a case of
has-
fraud. Unlike Byju's, this is a case of fraud, my lord. There's a big difference.
Fraud is by the 3C colluding parties.
They-
And that very order was challenged. A coordinate bench of NCLAT said there are 22 other creditors whose interests have to be protected. That order is not even considered in the impugned order. A coordinate bench has taken the view, very same argument was advanced.
Your lordship has to see what is the impugned order, my lord. The impugned order is only of collusion.
What issue is, my lord? It's an elementary issue. If, my lord, a creditor files a petition, either in winding up or in IBC, either way, my lord, the law is that if that creditor is either collusive or he withdraws or he settles, if there are other creditors, they are in the wings. the petition doesn't come to an end. Therefore, other creditors, my lord, will come over and take it over. So if, my lord, the present creditor is held to be collusive, petition is admitted, if he is out of the picture because of collusion or whatever, we are other creditors having, my lord, hundreds of crores worth of, my lord, debts. Therefore, we will step in, my lord, the IBC will continue. Then there will be a resolution plan, etc. That's the procedure.
1,100 home buyers whose interests are at stake.
There were 22 other petitions pending that day. They are staying in the wings, my lord. It's a rule, my lord, of 446 of the Companies Act. Same rule. Once you are in REM, if that petitioner, my lord, goes away or whatever, the others will take over. That is all there is to it. And Baiju's case has said so, my lord. It is actually a principle of the 1956 Act.
Lord, I am appearing for the appellant in 7.1. I was the operational creditor. On my section 9, the first order of admission of CIRP was passed. All these allegations of collusion, etc., were made against me. Notwithstanding the fact, as Mr. Vaidyanathan pointed out, that by a previous order, the Honorable NCLAT, 6th of January 21, had dismissed these allegations of collusion against me. Despite that, not by the impugned order on 23rd of August 23, my appeal is dismissed for non-prosecution. Even though I had been heard on previous dates, I had filed an appeal saying that after CIRP order had been passed, on applications, the NCLT had returned a finding of collusion. So I filed an appeal saying, please expunge those remarks against me. That appeal was dismissed for non-prosecution.
My lord, whether he is in collusion or he is not in collusion
Other creditors.
makes no difference because other non-collusive creditors are standing in the wings. That is all there is to it.
Yes. CIRP had to continue.
Yes.
We are all in agreement on that.
My lord, we are not, my lords. All of us are getting two promoters who had promised to do a project, are fighting amongst themselves. 850 home buyers are today in difficulty.
Yes. ED has conducted very.
And my lord, that CIRP, collusive CIRP is the one which shows that, my lord, what's happening.
Even if it is collusive, it's not.
Yes.
Who is one of the person who is 35% of the financial creditor is private to CIRP. Because what is pretty expected what is who hires? We have to see CIRP and by corporate insolvency that started. This was for the actual resolution of the entities, of the people getting their amounts. It cannot be a fraudulent process which is instigated. And what is
How about you start?
May start my appeal minute 797 of 2020.
That's the first appeal.
Yes.
That's the first appeal and let it be started, Miller. The impugned order.
But kindly have for my lord's convenience, we have a convenient compilation so that we don't have to go to various volumes.
Yes.
Yes. 697. Yes. 79.
It's a 6792. First is 679. Lead man.
So Vaidyanathan, how much is your estimate?
I will take about 45 minutes to an hour.
But if it is not likely to be finished today, then we may not be in a.
It can be.
Supposed to admit it.
This is a matter.
I think there is a short way of disposal. According to me, the impugned order
Yes.
is without hearing all the affected parties. That cannot start. Then the question will be whether it has to go back to NCLAT or NCLT. In my respectful submission, it is in the interest of having the parties and the matter goes back to NCLT. Then the proceedings will have to continue, and if anybody wants to go on application, Otherwise, it can be done. The NCLAT order cannot stand because on the very same question, an earlier coordinate bench of NCLAT has taken the view that the initiation of proceedings, admission of proceedings is valid. Therefore, this order is clearly wrong and it has to be set aside.
Where is
I
that?
don't think it needs to go back.
Where is that order passed by the?
Yes, sir. Would you also kindly have a look at the order? The order which is passed earlier order passed, that is 15/4/2020. I'm sorry. 6 January 2021, page 34 of the convenient compilation.
This was passed in appeal
1-1.
891. If government 6, page 34 of the convenient compilation.
specifically allegations of collusion.
That is
raised and
same.
rejected.
Can we hear one at a time? If it is not inconvenient to everyone.
Page 34. The Greeno Police Welfare Association.
Page 34 of volume 1.
Of the compilation, volume, convenience compilation.
We have convenience compilation.
Documents.
Has it been e-filed also? E-filed also? PDF? Oh, there is 7, then there is 7.1, in which you have filed it? I think item 7. All right. Yes.
The specific argument of alleged collusion is dealt with in para 9. The order is page 24.
Yes, Justice Chima's order.
Yes, sir. That's right. That's right. Now that apparently Greeno Police Welfare Association, which claims to be representing some of the home buyers. Now that the specific argument of collusion, para 9 at page 43.
So if you don't mind, please, there are 7 also.
Please. Yes.
There are 7 is most important, Miller.
Let para 6 first.
Yes.
In the present matter, one and two are now both under service. Both represented through different insolvency distribution professions. There are also IS 2742 and 2743 filed by company named Odisha Infrastructure under Rule 11. So of the rule seeking intervention. There is IS also by one ruler and then Roma, claiming to be representing 120 home by seeking intervention, claiming that the work should be continued. Before proceeding further, it would be appropriate to make brief reference to the developments before the present impugned orders and also developments which have taken place after the impugned orders, as well as during the pendency of this appeal. We are making short reference chronologically for appreciation. Well, since I want to make a brief submission, I am not reading all this and going straight away. The alleged collusion, para 9, because that argument is dealt with and Miller is rejected, they say, the home buyers other creditors. Yes. And will it please see page 43, para 9. We have heard counsel for the parties. Counsel for the appellant has made submissions on the above line and wants the impugned orders to be set aside. Counsel for the appellant claims that there was collusion between the two respondents and thus the admission order was bad. The counsel claimed that respondent number 2 is not an operational creditor as respondent number 2 had in the matter of Guptaji taken defense, which is contrary to the claim made in the present matter as operational creditor. Reference is made to the facts of that earlier matter, and it is argued that the admission order dated 26 February 2020 in the earlier matter recorded that the amount which was owed by the respondent number 2 has been assigned to person number 1. It is argued that this shows that the present respondent number 2, operational creditor, was acting only as an intermediate. We have seen the said order dated 26 February 2020 and the defense which was taken by respondent number 2. It has to be remembered respondent number 2 was corporate debtor in that matter. Para 14 of the earlier order recorded the defense of respondent number 2 in the earlier matter that it had entered into agreements with 3C shelters, present corporate debtor, and 3C projects collectively called principal employer. Defense recorded in para 14B in the earlier matter was that the corporate debtor submitted that the debt of the corporate debtor had been assigned to the principal employer of the corporate debtor. Appellant is banking on such defense recorded in earlier matter. On such basis, collusion fraud is alleged. We do not find any substance in such averments made by the appellant. Present application under section 9 is undisputedly filed by respondent number 2 at definition of financial control. Miller, those who set out. Then Miller, serve against respondent number 1 is maintainable. Order dated 2020, that is order 1610. And then Miller, please see para 13, page 47. The grievance of the appellant appears to be that it was the biggest financial creditor, and instead of acting on its application of respondent number 2 was admitted. How does it matter, Miller? Ultimately, the serve proceedings will have to go on. Prior D of the appeal also indicates that the appellant also wants serve proceedings against the respondent number 1 corporate debtor. IRP of respondent number 1 has been direct number also. 5 list of company petitions which are moved by stakeholders, including home buyer, against the present respondent number 1 corporate debtor. It is a list of 22 petitions in which it appears that the appellant had also filed CP number 1335 of 2019. Sumita Gogoi, who filed IA number so-and-so in this matter, was another petitioner with company petition number 503 of 2019. Intervener Dhruv Verma also wants self to continue. Even if we set aside the impugned order, there are others waiting against respondent number 1 corporate debtor. When respondent number 2 has operational creditor filed petition application under section 9 of IBC, the only consideration for adjudicating authority was to examine if there is operational debt due and default. It found the debt due of rupees 29 crores 95 lakhs 91,034 was not disputed and passed impugned order dated 20th July 2020 allowing. In such matter, after petition was allowed, adjudicating power had no power left to review the order. Now, this is the contrary view is taken in the impugned order. Had no power left to review the order dated 20th July 2020, especially so on vague surmises of collusion. We do not see any purpose of setting aside on technical grounds the SERP initiative. Order dated 16th October 2020, by which order the adjudicating authority has recorded reasons thus show that there was material to show debt due claimed by respondent number 2 operational creditors and default to seek SERP against respondent. If the application was complete, same was required to be admitted. Then they go on to show both are now under review. Trust I am going to follow the law. Yes. Yeah, I'll go to the
His filed 22 petitions, that one is time order. Subsequently, the status report of the ARP is 1100 genuine claims. Before and after.
This 29th March 22, the NCLT returned the finding of collusion.
One bench says that it's an interim order, the second bench keeps says that it's
They specifically said that my debt was due. They specifically said.
doesn't, that's the problem. Yeah, page similar 265, in the same volume, 265. Extraordinary. Not even considered, and says that the NCLT had the power to recall, should have recalled, it is collusive, and Miller doesn't consider that there are other creditors, and there is an earlier order.
And this order of Justice Chima
Yeah.
is not challenged here.
Never challenged, it has become final.
Although not my appeal, I was this operational creditor respondent to in this order. Although my appeal was dismissed by the impugned order for non-prosecution, but this earlier order of 6th of January 21 was on record because I filed it in my written submissions.
Now, kindly see Miller, the impugned order, which is at page 265, document number 50. Same volume.
Page number 274 is with para 20.
CRP proceedings are initiated.
Yes,
They are challenged by some persons.
we check.
Whatever it be. That challenge is negated
Yes,
by a speaking order.
yes.
Thereafter, somebody files an application for recall of the order for initiation of proceedings. That application is rejected by the NCLT. So in view of the earlier order of 6th of January,
Yes,
how could the NCLAT
yes.
sat in an appeal over that order?
Manoj, there is one.
Isn't there something like judicial propriety?
Yes, Manoj, one aspect. The issue, the collusion point which he's raising was a different aspect.
Might be.
Yes,
When one court,
yes,
one bench of one court
yes,
gives it imprimatur
yes,
that the order of CIRP,
yes,
initiation of the resolution proceedings,
yes,
is not liable to be challenged,
yes.
or the challenge to that is not sustainable.
Yes.
Whether the another bench could have sat in an appeal over
Manoj,
that.
what happens is, in fact, NCLT's order, para 51, distinguishes.
On the
Subsequently, certain frauds come to the knowledge, and that is why it is set aside. Manoj, that's why the CIRP is set aside on a totally different ground. Ground is
then that everything should have been gone into by the NCLT at the first instance.
Yes, that's what it has done.
Miller, who has filed the appeal? The appeal in the impugned order.
Can I not
Impugned order is an appeal filed by Rakesh Kumar Gupta, who is a resolution professional of 3C Universal Developers, which is the promoter company.
The 3C fraud, which
Well,
is
extraordinary.
My lords, may kindly let me see. The 3C fraud, which is subsequently brought on record, is there are pantry boys who are directors of 3C who are operating. And on that basis, my lords, at para 51, NCLT notices these subsequent facts. On that basis, on that fraud, it is set aside. My lords, we are home buyers, we are not worried about CIRP, etc. But our plots are in 857, I represent home buyers. Because of this delay in CIRP, etc., my lords, this is all, I'm stuck between two promoters fighting. My lords, we see para 51.
No home buyer can be aggrieved by the serve process.
It is.
Everyone has to get the home.
And the IRP in this CIRP is, my lords, filing a status report after the CIRP has been set aside. When and also moving to the High Court for orders regarding assets regarding which the status quo has
There
passed.
is a status quo here.
Yes, yes. And he's gone to the High Court, my lord. This IRP goes to the High Court and starts asking for directions with the High Court. Unfortunately, has passed directions on this aspect.
Justice Ashok Bhushan's bench specifically asked IRP to verify the claims, and Miller, that has been done, and that is what is being charged.
That status report is filed after the CIRP has been set aside. It has no sanctity. Yes.
Firstly, how could the another bench of NCLAT
Yes.
have passed an order contrary to the?
Because
Let us see how it discusses.
yes, we see para 50.
Kindly similar.
Mr.
Please see.
Vaidyanathan, we have called upon him. So.
Yes, answer. Very well.
Which page, Mr. Singh?
Must see para 51 of the NCLT order. Unfortunately, we have our convenience compilation. We can find it.
It is not in this convenience company.
Page 41 of the appeal.
The order dated 28th of August 2023.
Deep.
Para 51.
No, sorry. This is the NCLT order.
23rd of December 19, is it?
NCLT order, this is 29th March.
No, NCLAT order.
No, first the NCLT order, madam.
No, let us see NCLAT order because NCLAT has passed an order contrary to the earlier way.
Madam, that's in the review process. Page 3.
That is
What page, Mr. Vaidyanathan?
265 will have included.
On the same one.
Same
Yeah.
volume, document 50.
But then the last paragraph of that judgment, is para 27, so where do you get para 50?
22 onwards, paragraph 22
Upholds
onwards.
the NCLT order, which notices that there is a separate set of facts leading to the fraud. It upholds, and it
Point
says
it out.
because there is fraud, but since I have no inherent powers, I can't set it aside.
Wants to see.
That's why this-
51 of the NCLT.
Yes, NCLT order, my lords, is important because that gives the subsequent events which led to which is the basis of the fraud for the present setting aside of the CIR. Those facts were not to the knowledge earlier on. And that is why, my lord, I didn't know about it. I had filed an appeal. I didn't know about it, my lords. This comes into account in 51. Now, after
Where is that order? Where is it?
NCLT order, my lord.
NCLT order?
NCLT order.
401. 401 of the appeal.
That's page 65,
Or 65.
document level. Same one.
And let me see para 51 where they notice the subsequent events, which forms the basis of this.
Para?
Para 51. Madam, we see apart from may I read that? Apart from 3C Shelters Private Limited was being represented by Mr. Rajiv Basoya and Mr. Grish Chand Joshi. Oh, Madam, may I just start with 50? Sorry. I'm just. Yes. That will give the full conspectus, madam. Para 15. Further, it is to be mentioned that the demand notice in the present matter.
No, it begins it further before embarking upon the retail.
Para 50.
Para 50.
Yes, para 50. Yes, madam. It says further, it is to be mentioned that the demand notice.
That's at 110.
Page 400 of the appeal, madam. Malus is 110 of the CC, para 50. Malus would like me to read it or Malus is free?
Yes.
Yes. Further is to be mentioned that the demand notice in the present matter was issued on 9th October 2019, whereas the resolution of the Board of Corporate Debtors pertains to 24 June 2019, whereby Mr. Rajiv Basoya and Mr. Girish Joshi were directed to file reply. Hence, the company had already preempted that reply on behalf of the company must be filed with respect to the demand notice accordingly. Therefore, Mr. Rajiv Basoya and Mr. Girish just filed the reply in the petition. All these circumstantial evidence on the record indicates that there was collusion, active collusion between the corporate debtor and the petitioner herein to initiate the insolvency proceedings. Further, without any resolution on the part of the corporate debtor, some of the directors and petitioners herein got a memorandum of understanding dated 7/19/2019, even without involving Messrs. So and so, 3C Universal, which were actually parties to an agreement. Moreover, the said memorandum of understanding was not yet attested or registered. Therefore, the said documents were nothing but afterthought documents fabricated, created just to facilitate the initiation of CIRP proceedings. Further, the petitioner herein, without redeeming the securities, as alleged to have been stated to be secured by way of property, that is plot number so, proceeded to file the present petition. One of the erstwhile director, Mr. Suren Singh Suri, that is respondent number 4, categorically deposed that Mr. Bharadwaj, while deposing before EOW, categorically stated that his signatures on the memorandum of understanding were not genuine, which further puts cloud for the authenticity of the execution of that document. Further, there was no authorization or resolution of corporate debt in favor of Mr. Bharadwaj, Girish Joshi and Mr. Rajiv Basoya for execution of documents of any kind with State Edge Contracts Private Limited. Hence, even the alleged agreement dated 28/11/2017 also comes under cloud. Further, the corporate debtor was having in its escrow account rupees 53 crores at that time, and the corporate debtor, despite admitting the liability, did not prefer to pay the same. Hence, the fact creates a serious doubt about the execution of the very first agreement. Now, let us para 51. Apart that, 3C Shelters was being represented by Mr. Rajiv Basoya and Mr. Girish Chand Joshi, who were mere pantry boys or office boys of the company.
Correct.
To support the said facts, or is also placed on record their affidavit dated 24th February 2021, to Learned RP of the 3C Universal Private Limited. These affidavits clearly prove that these two persons were not at all aware of any of the activities of the company and they were not familiar with any documents, etc. Accordingly, they have also made requests to discharge and remove them from the directorship. Though some of so-and-so stated to be paid by 3C shelters merely relied on the documents and no such other documents pertaining to the execution of the work at the site, which might include the balance sheet and other job works and list sheets and list payment, etc., mode of payment were never produced. Absence of all these material documents further creates a serious doubt about the claim made herein. Pleading of the petition has merely been admitted by these dummy directors, Mr. Rajiv Basoya and Mr. Giri Chandra Joshi. Except this admission, there is no authenticated document to corroborate the fact whether the work was actually carried out at the site. Learned Rera also specifically held that no construction was going on Greenopolis since earlier 2016. Although the contention has been raised from Yahoo as a straight edge contract that it was not a party to that application, the said findings, if any, recorded are not binding upon it. But in this context, it is to be mentioned that 3C Shelters was in fact party therein, and the said complaint as well as other proceedings were duly contested by them. Further, Learned Herald also recorded the same finding, categorically stated and after that the construction of the project virtually came to a standstill early in 2016. It is 3C Shelters which admitted the liability in the present application, and the said issue is also hotly contested by 3C Shelters before Learned Hera as well as Hera. Therefore, the said findings are very much binding on the petitioner. Also, herein also, and as the interest stands accrued to it, to the respondent corporate debtor itself. And my lords, 53. So far as doctrine of merger is concerned, it is to be mentioned that Oris Infrastructure, though filed an application for intervention before NCLAT, but the same was declined. Neither RP of the corporate debtor nor the corporate debtor nor Mr. State Edge had never arraigned Oris Infrastructure Limited as party in the petition. Learned RP of corporate debtor also did not prefer to disclose this fact to the tribunal. So the factum of collusion has been discussed by the Honorable NCLAT in the order dated 6/1/2021, but apparently the said contentions were raised by Greenopolis Welfare Association. Therefore, the finding therein, recorded therein in the said order does not bind Oris Infrastructure Private Limited. Even all these facts were not in knowledge of Greenopolis Welfare Association. Moreover, the Honorable Supreme Court in its order dated so-and-so 31/5/2021 has given liberty to Oris Infrastructure Private Limited to file an appropriate application before the tribunal, and parties were relegated to this tribunal to decide on these issues. Therefore, now it cannot be said that the order dated 20 July 2020 stand merged in the order of NCLAT dated 6 January 2021, and this tribunal stands barred to go through all these issues. So, my lords, the issue of what fraud was, the nature of the fraud, etc., was totally different there. These are subsequent facts which come to the knowledge. NCLT says I don't have a power to review to recall my order, so it leaves it, and NCLT upholds this order of fraud, says that you had the power and therefore sets aside the CI.
But now my NCLT doesn't discuss, it only says that it has the power to recall and we recall. But it doesn't it doesn't discuss as to what fraud is there, how it is. It finds that the finding of the
it accepts these because it does not dispute the setting aside of the CIRP. Otherwise, there were hearings held.
Can we hear one at a time?
I'm sorry. And my lords, what happens is this. Now what happens is after this CIRP set aside, the IRP suddenly comes up with a status report filed before this court. On what jurisdiction, on what capacity, my lords, not known. And then, my lords, that status report, there is already a report of all the allottees, etc., which before RERA by a forensic auditor, which gives all the allottees which are there. My lords, we are not worried about it.
Mr. Sen, you tell me, where is the only consequence of 65, a dismissal? It may happen that the initiating party may have colluded.
Yes.
Otherwise, you can game the system.
Yes.
And then it turns out that in the process of admission that there are other genuine creditors.
Yes.
Why cannot the NCLT constitute a committee of creditors with the genuine OCs in a OC case or FCs in a FC case?
Yes.
Punish this man under 65,
Correct.
but let the CARP to continue. Otherwise, with 100 creditors, you will be first past the post with a colluding party, and then let the whole system set aside, leaving the others in the lurch. Why should where it 65 says, where it says dismiss the CARP?
Yes.
65 says penalize the colluding party.
The submission here will be twofold.
So you tell me,
Yes.
otherwise you see you can game this system.
Exactly, but the gaming which is happening is larger. The gaming which is happening is larger, what we are pointing out.
It's clarified that the stay would mean that the proceedings before the NCLT would proceed in accordance with law.
Yes, we have bring out this which is there. We are, may kindly point out.
Yes, thank you. Next matter. We'll hear it finally, yes.
One clarification, one of the joint venture parties is using the pending proceedings and not handing over the flats. This matter should not come in the way of handing over.
So, we are saying that NCLT will proceed in accordance with, you get the orders from the NCLT.
Now this COC will have to be constituted.
Other joint venture party is obliged. Just one moment.
No, that the IRP will move section 60 subsection 5 application.
The second order of NCLT is not sustainable in law. It's a gross judicial impropriety. If you want, we'll set it aside right now and let the
Just one request. Not this current IRP. This current IRP has a lot of complaints.
We further clarify that. If any of the parties have any objection with regard to the conduct of the present RP, is it RP or IRP? IRP, you would be entitled to move an application before the learned NCLT for change of the IRP, which application would be considered.
What has happened is his conduct extends to this form.
So you pointed out to the NCLT.
No application.
Mr. Kohli, with such sort of allegations by any of the parties, would it not be appropriate for you to walk out?
Specifically made a submission.
So, can we, if we have your permission, some of the parties have raised serious grievances with regard to the conduct of the IRP.
Disputed with Kohli.
Though Sri Kohli, the learned senior counsel, appearing on behalf of the IRP, disputes the said allegation. But we do not find it necessary to go into the said allegations. The parties which have a grievance with regard to conduct of the IRP would move an application, would be entitled to move an application before the learned NCLT, which application will be decided by the NCLT as expeditiously as possible, and in any case, within a period of 4 weeks from making of such an application. We clarify that we are not expressed, we have not considered the merits of the allegations and the rebuttal thereof, and the learned NCLT would take a decision on the basis of the material placed before it. Mr. Sibal is there.
If that application is decided,
He should not.
You keep your hands away, Mr.
Yes.
Okay,
From today onward,
They should not dissipate the asset. The promoter should not dissipate the asset.
Which is passed by this court on chief ke order, by this court on such and such, shall continue to operate, which means that the IRP appointed shall also not take any steps till the next.
in fact, we had filed a.
IRP yourself.
Not take steps, he will be accountable for the company.
Let the ED has.
There is a contempt, my lord. Contempt has been filed against the IRP, my lord. Yes.
Let us go for this. Till the orders are passed by the NCLT, the order of status quo passed by this court dated so and so shall continue to operate.
Yes. Okay. So,
Yes. Thank you, thank you. No, thank you.
May I take 2 minutes? I'm the appellant in 7.1. But I was the original operational creditor against whom all these allegations of collusion were made. But after the NCLT passed the order of 29th of March 22, I also filed an appeal saying that please expunge these remarks. I've got material to show that these allegations of collusion were not founded. Now, my lord, the NCLAT by the impugned order dismisses my appeal for non-prosecution. So, my lord, now what happens to me? Because I am seriously disputing those.
The 7.1, the order passed by the NCLT, by the NCLAT, dismissing the, you have filed an application.
I filed an appeal 651 of 22 against the order of 29th March of 22 of the NCLT saying, and I also annexed the earlier order of 6 January 21. I said these allegations of collusion are wrong. Please expunge these remarks.
The grievance of the appellant is that the observations made by the NCLT in its order dated to second order
29th March 22.
29 March in para 57.
It's the same date, 29th March 22.
29th March 22, with regard to collusion are unsustainable, and therefore he had filed an appeal for expansion of the said remarks. Paragraph. It is the further grievance that the said appeal has been dismissed without giving an opportunity to the
By way of the impugned order.
petitioner, to the appellant by way of the impugned order. Paragraph. Anyway, we set aside the order dismissing the appeal. The appeal of the present appellant is restored to the file of the NCLAT, which would be decided in accordance with law after hearing the parties. Everything, everybody will maintain status quo. Mr. Soni, we are not passing any order. We are not passing any order, but don't do anything for a period of 1 month. And we would expect that
Either is a statement be recorded, my lord, or your lordship should pass the order.
we have a practice of believing in the statement of the conscience.
Lordship, I am grateful for not passing it specific.
You advise your client, and we believe in your word that you will not do anything for a period of
That's why, but Lordship, why are only one sentence? They are, this is Lordship, Lordship, I must point out, the promoters are dissipating assets, so they must hold their hands.
My lord, in fact, we have to file a contempt against them. My lord.
Great.
Contempt is to be taken.
We have called out item 8. This is coming up for the first time before us. We don't know why it traveled from that court to this court.
Only one thing, my lord, I have filed a contempt. I have filed a contempt because of the action of the RP. my lord.
It will go in accordance with law.
Either the contempt notice be issued and they have to face it, or they should give an undertaking.
The contempt petition is disposed of with liberty to the petitioner.
Okay.
File an appropriate application before the NCLT.
I have also filed a contempt, Lordship, so I'm all get
which will be considered in accordance with it.
No, Lordship, I have also, so therefore, in fairness.
You have said that they will decide within 4 weeks.
My lord, in the earlier matter, my lord, in 7.1, against the collusion findings.
I think today must have been a real. Today's day must have been a real Diwali day for the.
Lordship, Diwali and Christmas combined.
The findings of collusion and appeal was filed earlier also, which was withdrawn by the promoters.
Yes. Next matter.
You raised that objection in the NCLAT appeal.
They have already withdrawn, the promoters withdrew.
That's been
My
objection.
lord may say all objections will be left. All
You have said that in accordance with law after hearing all the parties.
This status order is not coming that way. Lordship, I must assess.
Serial number 8 taken.
Mr. Sen,
Item 8.
unless all of you.
Yes, serial number 8. Who is in serial number 8?
Grateful, Lord.
Thank you, thank you.
Thank you, Lord.
Kindly appreciate this.
Who is in serial number 8?
8.1, my lords.
Yes.
My lord, there is-
Proceed.
my lord,
My submission is this.
I am appeared responding across. The council for requested for a short
we have already
adjournment
called on the-
yesterday on the ground of bereavement. However, my lords, we have a request to make, my lords. My lords, exams are appearing, exam is conducting today at 2:30 PM.
You pursue with that NCLT, everything we have now.
Because of this rigmarole, 2011 project, my lord.
Mr. Lauti, don't allow yourself to be divided, otherwise you'll be in this stage for another.
This happens because of the joint venture. The home buyers, some of the home buyers are, have formed. Now the.
Actually, Mr. Lauti, at least before NCLT, something could be done. If the matter remains pending here for years, nothing will happen here.
We just clarify on this project now that we can pursue those remedies. Against audits.
How will you execute it? When it comes to execution, how will you execute it?
But because of the status quo under the.
How will you execute it even if it culminates with a sense? Concentrate here and get the, some promoter who comes in and gets your project going.
Yeah, that's against audits, not against 3C.
Our
Audits is the project
concern is, our only.
Audits we may be permitted to pursue our amendments.
Our only
Yes, who is in
concern.
8.1?
8.1, my lords, I am.
My lords, I am appearing in item 8, my lords. It's for the applicant's college. Counsel for the respondent requested for a short adjournment yesterday on the ground of bereavement in her family. We
There's
have.
an IA.
There's an IM, my lords. I'm appearing in 8.1 for Ms. Ankita Chaudhary, my lords. There's a bereavement in the family. I'm requesting.
I'm
for-
just requesting, we have no objection, but we are just requesting, today is the last exam, my lords. If students could permit to write the exam without prejudice to the rights of the parties to contest this IA, my lords, subject to the outcome of this IA.
Next week.
In the Allahabad High Court has now given a judgment upholding the entire this examination and selection. I wish to file that before your lordship. Your lordship will only call next, and has also exonerated us of any charge of conspiracy in the challenge to the examination.
Led by Ms. Prashad. We also have just received this judgment and we want to produce a copy. So we also seek a short accommodation.
So when do you want? 2 weeks, 3 weeks?
Next
2 weeks, my lord. 2 weeks if it's possible.
I'll file it, my lord, because judgments.
2 weeks, 2 weeks.
May I please, my lordship?
Here, your lordship.
Oh.
In the first round, your lordship.
Right, okay.
Here is the order.
I see.
Not to be placed before the bench of which Vishwanathan legal member.
Is the order? Have you appeared in this very proceeding? Otherwise,
No, yes, the
I
same-
can't burden my colleagues simply recusing.
The first round. He is one of the accused.
Chinnaraj.
Yes, your lordship.
But here only two accused are there,
No,
Sengutuvan
there are
and
six-
Anand.
Six, he is one of the accused. Your
Accused are there. Only two are before the court.
Yes,
I think.
Two are before the court.
Others are no more.
They are all.
But I case is same, he says.
Yes, same, your lordship.
Others are no more.
Indeed, your lordship.
Lordship may give any date, madam. Item number 10.
We can't give date.
Right, Lord. Right, it was only adjourned, the matter is there. So even Lordship appeared, there was only adjourned matter.
What Mr. Lenin says is, in a council, you have fully read the brief, fully absorbed it. I don't want to discuss that presumption, let it be there.
Your lordship, I don't have any objection. I'm ready for argument. Your lordship. Nevertheless.
Same case. No.
Oblige, my lord.
You have presumed something in my favor.
Yes, who is for the?
Mr. Guru Raj, sorry.
Yes.
I've been in incarnation for 9 years, 9 months, and I gave pensioners who get in the pensionship the fee.
Yes, Mr.
Undergone period is 7 years, my lord, 1 month. Excluding remission, my lord. Including remission.
What are the antecedents?
My lord, apart from this case, my lord, 4 other cases.
I thought you mentioned 8.
He's been acquitted in all the matters. Is this on page filed by my learned friend only?
Eight. Counter there.
8 cases are mentioned in the counter.
But he's been acquitted in all the matters.
All the 8 matters.
No, I think some are pending.
So as per my instructions, I've been informed that.
No, but Shifali, serial number 1, serial number 6.
It's not
One is
mentioned.
dismissed as withdrawn.
I've been informed that they checked that he's been acquitted. The matters have been settled.
9 years, 6 months. How much now? Total undergone?
7 years, 1 month.
No, but with remission, I think 9 years.
9 months. And other 2 accused have also been granted bail during the pendency of the appeal.
Most of them he has been acquitted. The petition challenges order passed by the learned division bench of the High Court dated so and so, by which an application for suspension of sentence came to be rejected. Paragraph, the petition is vehemently opposed by the learned counsel for the state. It is submitted that the petitioner is involved. The petitioner's past record would show that he is involved in various yes.
9 years, 9 months.
The petitioner, actual or with remission?
With remission.
With remission.
The petitioner has been incarcerated for a period of about 9 years, 9 months. Also, taking into consideration that the appeal is of the 2017, there is no possibility of the same being heard in a near future. We are therefore inclined to allow the petition. The impugned order is quashed and set aside. The order of conviction or the order of sentence is suspended during the pendency of the appeal before the High Court, directed to be released.
My lord, starting with the lighter note, same order, my appeal is pending. I've been in 2 years in jail, 5 years in the sentence, no evidence of the mobile recording found.
11 years old victim, my lord.
But,
No reason to falsely implicate, my lord.
My lord.
164 statement is there.
164
Other statement is also there, my lord.
Kindly see, my lord. There is, the FSL report even does not suggest that any.
5 years.
5 years, 2 years.
2 years.
2 years
Two
has
years.
undergone. Exactly.
Carrying fish.
Exactly.
But the girl will have no.
No, you're right, you're right. No.
And her 164 statement is also there. Mother
decided I'm merely.
Yeah, evidence is there. PW4, no?
Yes.
PW1 annexed later.
He came.
Page 109. But she vacillates in the initial portion a lot.
Only so far as they're putting the hand in the. Otherwise, rest of the things here, just a minor contradiction.
Otherwise, my lord, as per section 11.
Which appeals are being heard in the Delhi High Court?
Honestly speaking, the regular matters are not being taken up.
Huh?
Regular matters are not being taken up from last many years.
Delhi High Court? No regular appeals are taken up.
Very rarely the appeals are. There's only.
If it is a short appeal, it can be directed to be taken.
But then they are not being, then why should he be made to jump with an application for suspension of sentence. The application is vehemently opposed by Raja Thackeray, the learned AG appearing on behalf of the state. He submits that the petitioner is involved in a heinous offence, and as such, the High Court has rightly rejected the application. Correct. The applicant has been sentenced to suffer a sentence of 5 years. Out of that, he has already undergone almost 2 years. There is no likelihood of the appeal being heard in the near future. We are therefore intend to allow the application. Pehle wala order.
I know Mr. Raja Thackeray and we both have worked in Bombay High Court together.
You worked in Bombay High Court?
I appear, go and appear Aurangabad, Bombay.
You have never appeared before me.
No, and subsequent.
I've been at all the places, Aurangabad, Nagpur,
used to appear at
Aurangabad, Nagpur, Mumbai, and even Goa also. Mr. Thackeray used to regularly appear.
Luckily, I got the chance here.
Time for the respondent state, give me 2 weeks time to file my counter affidavit. Now the Lordship please issue notice.
Yes.
Notice was able to file my counter affidavit.
He has undergone the sentence or not, isn't it?
Yes, he is completed, is already into 1 year extra, which was awarded by the.
He wants a common job.
Revealed by the.
Yeah, 302 is converted to part 1.
304 part 1.
Moving forward.
Criminal matters, what is the necessity of finding counters? We don't know. We have to decide as per the record, as per the evidence. Unless it has something to do with material aspects, we don't. In High Courts, we never file up replies in the criminal appeals. The matter has to be decided on the basis of the record of the trial court.
Coming after notice, my lord. This matter offers to suggest, my lord, that service was effective to respond to accused, but he has refused it, my lord. So, my lord can keep any day for my argument. Can keep any day for my argument.
Jobbins.
State your lordship.
And who is for the complainant?
My lord, I am for the complainant, my lord, petitioner complainant.
Yes, you are against
My lord,
against grant of question.
R2.
My lord, office report say that he refused, my lord, service. It was effective from the registry, he refused. That came in the office report. Or if they can be, my lord, he can be served through a state, my lord.
So the office report shows that the respondent number 2 has refused to accept the service. Also, in order to give one more opportunity to the respondent number 2, issue fresh notice returnable office. We direct the respondent number state to serve the said respondent through concerned police station.
Marshal.
My lords, I'm appealing for the state of UP. My lords, I'm seeking 1 week time to file my application.
Yes, obviously, Haryana will look after.
If I may, lordship, just seek the indulgence.
And my lords, this corner number 1 is unserved.
Union is unserved in this matter, although not a relevant party.
Which one?
Item 15, my lords.
15, I think.
Union respondent number 1 is unserved in this matter, although
It's a formal party, yes.
Yes,
And who is appearing for the state of Uttar Pradesh and state of Haryana?
My lords, I'm for the state of UP.
UP.
Yes, Lord.
You are ready with the matter?
I'm seeking a week's time to file.
2 weeks.
If I may just, lordship, seek permission to mention 19. Lordship, 19 had come up before lordship on 11th. It's been listed on 17th of December. The learned senior counsel.
Somebody mentioned.
Yes. But it's come up in the list today again. It's actually, next date is 19.
This is that demonetization.
Yes, lordship.
Somebody mentioned
Jerry
it.
Gupta's son is, I think.
It is admitted, but it will have to go in January now.
Lordship has fixed 17 December, if Lordship would be so pleased to.
We were not aware about the change of the roster system at that time.
I understand Lordship, but since Lordship already passed an order, I thought if I may pursue it and request Lordship to keep it on 17 December.
Mr. Athres, where were you in the morning yesterday? Nobody appeared for.
In item 4, my lord, my name is not there, Wakalatnama could not file, but give me 2 weeks time, I will take instructions, I will finalize.
I'm so great.
In item 4. Please.
Deeply obliged, Lorships. Well, your lordship may have the order which your lordship passed on 11th of November in this.
May you kindly see the chart I have prepared for each and every matter. There is 27 matters, my lord. Out of 27, in 9, 2 matters are different, my lord. 25 matters are belong to the estate of UP, my lord.
25 matters belong to?
State of UP. And out of 25, my lord, in 16 matters, inspection has been done and either deficiency has been communicated to the college or final decision made. In 9 matters, my lord, they did not permit the inspector to enter in the premises. That is there, item 36, 36.2, sorry, 36.2, 36.5, 36.6, 36.9, 36.10, 36.17, 18.
But yours is inspection arranged but not yet conducted.
Yes, because they did not permit the inspector to enter. In the premise that they have filed the application. I have no objection, my lord, is my lord's permit us to inspect the college and grant the approval as per the.
Why you did not permit them?
The very prayer thought in these applications is that we were granted approval at a stage where, my lords, we could not even get affiliation and we could not admit any students. So the approval granted in the previous year be considered as approval for this year. And my lords, in 23, your lordship passed so many orders. I brought those orders. Their approval was granted at the very last stage and no affiliation and no admission. So your lordship in February, March, April, till May, my lords, in several cases directed, my lords, that approval granted in 22 should be considered for 23-24. Likewise, was on 23rd September, the order that has been passed by your lordship in one case, that was a case where approval was granted on 30th November 2023, which was the last date fixed by your lordship on their application. Now, when approval is granted on 30th November 2023, and it takes about 3-4 weeks time to obtain affiliation from the affiliating court, by the time that affiliation, the last date for admission is over. So it was a 0 year. That is, in those circumstances, on 23rd September, your lordship directed that this approval for 23-24 be considered for 24-25. They have, my lords, complied with that order recently and granted to that institution approval for 24-25 without inspection. The whole case is that why inspection where the things are moving since 2022, your lordship has dealt with that moratorium matter. Since 22, none of the institutions are able to take part in counseling as far as UP is concerned. In all the states, though your lordship is fixed 30th November as the last date for grant of approval. In Madhya Pradesh, counseling is almost over. Maharashtra counseling 2 rounds are over. Because of this legislative assembly election, the state authorities have put the 3rd round on hold. Haryana, the counseling is over. Everywhere, counseling is over. Now, this kind of seeking extension of date for
Applications are rejected.
Lord,
36, 36.1, 36.2.
that your lordship may make alternative submission.
That we have been telling you from the other day also. If you are averse to inspection, then we will not consider it.
Your lordship, no, we were trying to point out that why
Rejected.
the alternative lords may have request for it.
If somebody is averse to inspection, why should we entertain?
Your lordship, I'm making alternative submission. Since some of the institution as well, is pointing out, since the matters were filed, they may have refused. Your lordship,
Why should they refuse an inspection?
Your lordship,
Filing our petition is not a license to.
since your lordship had passed an order on 23rd September, so it was felt that maybe same order is passed. But now, since your lordship has extended the time till 25th and final date 10th December, so your lordship may say in these cases, the inspection will take place within this much time and will cooperate.
He said it in the beginning itself, but you were averse to that.
Your lordship,
Now we won't grant that.
please kindly consider that.
No, you have to be fair, Mr. Sharawat. When fair suggestion is coming.
Only, I was just trying to point out that this was happening every year and
Therefore, we should grant you permission without inspection.
So yeah, your lordship may kindly consider fixing some time only in these matters and your lordship will allow that.
Which are those matters?
In
all other matter except 9 matters, my lord. Item 36.3, my lord, inspection has been done, deficiency has been communicated. 36.4, my lord, inspection report received, my lord. 36.5, refused the inspection. 36.6, my lord, refused the inspection. 36.7, compliance has not received, my lord, deficiency has been communicated, my lord. 36.8, my lord, report received, my lord, decision is pending, my lord. 36.11, 36.12, 36.14, 15, 16, 19, 21, 23 different blocks, 23, 24, 25.
I believe in these matters, inspection has already taken place.
Yes, so they will consider it, yes, and pass approval.
That your losses may dispose of bloods or order your losses are pending for that. And they will also inspect bloods wherever they want to inspect or bloods. We are absolutely not averse. I prepared a chart bloods along with my other trade. I think most of the cases they have carried out inspection. And again this year also they have carried out inspection. And we are willing bloods, they want to carry out bloods throughout the year, they can bloods, there is no difficulty. If I may pass on. Your losses may dispose of bloods, carry out inspection wherever they want.
Very common orders.
Okay.
Very good.
Your losses will have.
You are covered in this 36 order. You are covered, no? Very good.
The order I have annexed at page 2 of this. But if this chart your losses will have, plus I have also annexed the order that you also have, and plus I have given one approval letter at the last page 4. Page 4 is the approval letter which they have given, that throughout the year they want to carry out surprise inspection also. Your losses may also observe the inform it's better to have surprise inspection also. We are willing to have that. That's no difficulty at all.
Lord, inspection is due only in 9 cases.
But the order is at page 2, which your losses have.
The learned counsel for the pharmacy council has given a list of the matters and their present status. It is submitted that in how many matters inspection is carried out?
In 16 minutes.
In 16 matters, the inspection is already carried out and the inspection report is conveyed to the institute's concerned. He however submits that in the 7 matters, the 7 or 9?
In 9.
In 9 matters, the inspection could not be conducted since there was resistance from the institutions. Paragraph. Shri Sherawat, the learned counsel appearing for the applicants in some of the matters, some of such matters, states that since the court has passed a similar order on 23rd of September 2024, the applicants did not find it necessary to undergo inspection in as much as they were under an impression that in view of the orders passed by this court dated 23rd September 2024, they would get automatic approval. Paragraph. Shri Amitesh Kumar, appearing in some other matters, fairly states that he is not averse to inspection. On the contrary, he states that the surprise inspection could be carried out throughout the year so as to ensure that institutions are being run in a proper manner. Paragraph. We dispose of all these applications with a direction to decide the cases where an inspection is already granted prior to cut-off date so that the institutions can avail of an appellate remedy Paragraph. Insofar as the inspections, in institutes where inspection is not carried, so we direct the pharmacy council to conduct an investigation and
Inspection.
conduct the inspection and take a decision before the cutoff date goes through. If any of the institutions resist to inspection, it will not be necessary for the pharmacy council to consider such application. Paragraph. D. Stand disposal in the opposite.
There are also 15 MA which could be listed. In all these cases, inspection has been done, they have pointed out deficiency, you are not paying for it.
But I'm giving a list, so all these MAs can be disposed of in terms of the sale.
Under 36.22 is referred, it is similar to 77, where my word is taken and given 40 normal. Mr. Pandey is not done this. If the people have not submitted this year, for the in pharma process, due to.
No, we had passed an order in the particular faction, so we won't go on passing the orders in the last date.
With permission, my lords.
It will be opening a Pandora's box now. Yes, thank you.
With permission, my lords, item 36.13, my lords. My lords, what is happening, my lords? One of the inspectors are refusing for the inspections. There, the case is not that institution is refusing for the inspection. No, my lords, at least there should be some.
Yes.
My lords, the case is that one of the inspectors are refusing. They are not able to come for the inspections. In these cases, they should take some measures, my lord, because in many of the cases there are 3 inspectors. 2 inspectors are ready for inspection. One inspector refused at the last moment that he is unavailable.
They will ensure that the inspection is conducted.
Yes, because that item is also covered. Your lordships have passed the direction, they will inspect. So that will be taken care of. So
Oblige, my lords.
I will apply next year, but they can consider this AOC for next act.
We don't want to pass order again. Mr. Sherawat will come in the next year, and I have been granted permission for 23-24, so no inspection this year. No.
My appearance will mark.
Yes.
My name is not showing the permission. Apply.
Bold में mark कर लेना.
Please grateful.
Deeply obliged. Deeply obliged.
My lordship, I am appearing for the respondent, my lordship, seeking time to file the counter, my lordship.
Yes.
We have to file counter in this case, my lordship, so seeking time to file counter.
All the 3 observations made by the High Court.
Mr. Shiva Prakash, Gita makes the demand, Sudha Gita. You just show something.
But actually, it's completely bereft of the use the word perverse finding, but this is the perverse finding.
No, there are other cases which have been quashed, but this case, when you see, so demand from by him.
Demand is, there is a telephonic conversation, page 76 of the complaint. The specific demand by him, you bring 10,000 now, then your file will be moved, thereafter another 10,000.
No,
Sudha says you have to pay 20,000 rupees, but he breaks it up to 10,000 and 10,000. He breaks up the demand. And he specifically says, I also took the Kannada document, I'm not being able to annex the.
Trap party also goes only to Sudha's house.
From Sudha's house, they go to CDPO's house. In CDPO's table, 20,000 rupees is kept.
Who keeps? Sudha keeps. Well, where is the demand by Shiva Prakash?
He's already demanded months. He has demanded 10,000 rupees telephonic conversation. Version kind of pay 76. What happened in the High Court? Some scenario where the fire stage they're watching. They don't even allow it to go to the investigation stage. So at the FIR stage, it was
When?
2 weeks, maybe.
2 weeks to file counter. 2 weeks to file counter. In the event the petitioners desire to file any rejoinder, the same shall be done 2 weeks thereafter, put up to 4 weeks.
Please, Your Lordship, I'm appearing for the respondent state. Your Lordship, I'm seeking 4 weeks time to file counter.
We could inform the petitioner's father that the petitioner's father on 27th. We would like to place that back on the. If the lordship may allow, if the matter could be listed anytime before
20?
Lordship, we need 4 weeks time. We need to seek instructions from the department.
Oh, we don't understand what instructions you require in such matters.
It's coming up for the first time after notice, Your Lordship.
So first time is an adjournment time. But next week रखना 27th के पहले.
It is not. The various provisions of the Cinematograph Act and rules and guidelines. I have one request. The record is quite voluminous. Proceedings are complete. I was only requesting your lordship's.
But why should all such petitions be filed directly before the Supreme Court?
Today, your lordships have the pleadings have been completed today. It raises the issue of the judgment in Abbas, not considering your lordship's earlier judgment in Bridgebush. And we made out a case of discrimination specifically with documentary films. When the certification of documentary films, it is our respectful submission that documentaries do not fall within the definition of cinematograph, as defined under the Act. The provisions, provided for constitution of the board and the advisory committee. I'm sorry. Therefore, it was, I'm being led on that. So that was our submission, that the constitution of the board, as also, the advisory committees under the Act required consideration, because there are no qualifications prescribed, as to who should be the chairperson. There are 25 members, what sort of qualifications these members should possess, their experience, in the field of certification of films and such, other forms of audiovisual demonstration. Therefore, we are only requesting if the lordships could give us one opportunity, we'll place on record a short written synopsis, only assist your lordships.
Yes. Entirely cease pre-censorship in films also.
Yes. And therefore, although there is now an enactment that the Union government has notified on the 5th of August 2023, that does not address the concerns raised by us in the writ petition. It makes very minor modifications to the provisions under the Act. It provides for certain classifications, for age-based classifications for certification, etc. But insofar as the provisions that we have put in issue, the amendment does not deal with any of those challenges. So, lordships could kindly have this in January, we'll put in a note.
Why should we enter?
Connected matter, my lord.
This is like saying 19(2) restriction also should not be seen.
That's not what we are saying, Lord. We are not saying that, my lord. In fact, we are asking for, my lord, if your lordship sees, one of our prayers is that the government should frame, my lord, if your lordship sees, my lord, one prayer specifically to answer that query, my lord. The lordship sees page 77.
Yes.
I'm sorry, my lord, page 78, Roman 10, my lord. Because we are focusing essentially, my lord, on documentary films, my lord.
So you are in the prayer.
Yes, my lord. I'm sorry. Prayer at page 78, paragraph 10.
Oh, first matter hard copy then. First matter is not uploaded.
Yes, one, sir. Please. I'm sorry.
Yes.
Lordship sees prayer 9 and prayer 10 at page 78. Reading down of provisions of the Act so as to exclude from its purview documentary films and declaring documentary films do not fall within the ambit of section 2C, read with 2D, double D of the Cinematograph Act.
and consequently not subject to pre-censorship norms, then please see 10, my lord. Directing the central government to frame appropriate rules so as to incorporate provisions of disclaimer, text, appearance, length, etc. that should appear before the beginning of documentary films, and to that extent alter the provisions of the Act. So, my lord, we are today saying, my lord, that as far as, my lord, the concept of a cinematograph itself is concerned, a documentary may not fall within the definition of Cinematograph Act as defined under the Act, my lord. Pre-censorship of such films, my lord, certainly is something, my lord, that the court will look at, my lord.
Aram Seshadri and all issues.
Yes, my lord. And, my lord, Bridgebhushan specifically dealt with this issue. Abbas, K. Abbas, my lord, with utmost respect, my lord, has completely, my lord, overlooked the judgment in Bridgebhushan.
Hidayatullah.
Yes.
Okay, thank you.
So when do you want?
In January, if your lordships would be.
I would also, as an officer of the court, it would be better if your lordships have the advantage of a high court determination on all of these exhaustive prayers. There are developments that have happened. I don't know if they want to amend their prayers also.
I don't, because the Act does not amend it.
Because now notification does include some regulation for OTT, pre-censorship, etc.
Correct, but doesn't deal with documentaries, my lord. Our principal
It's a
concern.
developing field. If your lordships want to hear, can't say, man.
7 years.
And pleadings are complete.
As
And
my
to start with, you may have judgments unless they establish that it is
My matter is also related to this. In this, there is a more fundamental issue of what constitutes, as far as they are concerned, public speaking. What is the public speaking? So you can define arbitrarily what has to be censored, what doesn't have to be. As this is what you answered my question. They have not said an answer to that for 7 years.
Which is the other petition?
Proceeding once.
Mr. Pankaj Butalia.
ठीक है जनवरी में जाना.
First week we will say.
If they don't want to, we can't compel them to file response.
I will examine it, my lords. I was not aware that the secondary petition has separate issues. I'll examine it, and if required, we'll answer.
In fact, there was a small issue also of amendment. We want to add one particular clause, an issue which pertains to a clause 6 in the Act, which gives the federal government overarching powers to overlook anything that the census board has done, and the film certification board has done. So we wanted to amend, then to be able to put that in also. That was a very matter also.
You want to amend the petition?
So when we should put in this clause, this is put in 3 years ago, 2 years ago. It's not come up since then, so unfortunately. It's still pending.
So you want to amend the petition or not?
It's filed an application. I filed an application for that.
You already filed an application.
Already filed an application 2 years ago.
You are suggesting self-regulation.
No, I was first of all suggesting that if the censor board has to take a decision with the certification board, the central government should have an overarching power as under clause 6 of the Cinematograph Act. Say it can on its own for whatever is given. Overlook and decision taken. I can take
Yes.
We'll allow that so that you can respond to this also.
We don't have the application, but we'll answer, my lords.
Just it's only one ground. It's an important ground. He wants to give it independence. You are a regulator.
Please, my lords.
Application for amendment is allowed. The amendment will be carried out in a period of 1 week from today.
Their prayers may be at variance with each other. One is saying down to and this. We'll see, my lords.
That is it's not your control. The kind of we must have control.
Yes.
We are the elected government. We have to have control.
I'm talking about the board. What to do.
We'll answer, my lords.
I explained to the board not before you were not aware of. I explained to them. I read 3% based document basis. I'm a filmmaker of 25 years of standing. I've been waiting for 7 years from I'm 75 years. 1/10 of my life is gone in waiting for a hearing for this case. I like
It's coming up before us for the first time.
And we are ready. They wanted time to put together a compilation.
My time is time.
As far as we are concerned, we are not adjourned it even on the single occasion. It's coming up for the first time today. It has traveled from the other court to this court. We don't know the present, what will be the system in January, because this present system will go on till December end. So, after January only. You are going for shooting some documentary. We wish you happy birthday in advance. Yes, we always. Yes. Extend the case law. And then in case we can prepare a joint compilation of the case laws rather than.
Abbas is how many judges?
No, 5.
We'll have to share it briefly.
Mention it in January.
Very well. Yes.
An interesting passage that, as it is wrongly said of a Frenchman, Abbas.
As item 20, the prayer was for accessibility guidelines, Manoj. We've actually complied with it. Your Lordship's wide order dated 7th February 22, my lords, had directed us to find a solution. Actually, I'm sorry, 12th November 21, my lords had directed us to find a solution, my lords. And my lords, we have now placed, if your lordships will have our affidavit. Well, at 17/9/2024, affidavit, if your lordships will see, permit me to just place some orders first, my lords. Kindly have. Order dated 12th November 21, my lords. May I have the order sheet for a moment, my lords? 12th November 21, my lords. So, my lords noted that that department is not treating it as adversarial. Then my lords permitted us that we will constitute an expert committee of concerned department. We'll be able to find out solutions to the issues raised by the petitioner, and to the extent doable, solutions will be implemented in right earnest. And if certain issues require some time for implementation, that would be presented before the court on the next date of hearing, including issues which cannot be taken forward at all. Well, the issue was for guidelines for accessibility, Malats. Digital education guidelines. I'll just show, may I just please?
Speaker of November, the Chief Justice made an order, isn't it, in one matter?
My lord, grateful. Grateful. Rajiv Raturi, I'm carrying copies of the judgment. My learned friend would hand it over. Mala, that's a very, very important point, because there has to be, firstly, the nomenclature is problematic. When we call them guidelines, it gives a notion as if it's just setting up some sort of standard which may or may not be complied with. It really doesn't give that notion of it being mandatory. Also, because then if we call it rules, those rules would then also have to lay down what would be the consequences if it's not being followed. And in fact, the Rights of Persons with Disabilities Act itself provides for the consequences. In fact, our prayer also said so, that there has to be a timeline within which, if the institutions fail to comply with it, then consequences ought to follow. So if my lord has the judgment.
Yes.
Allow
Place
me
the
come
conclusion. Conclusion
My
part.
lord, may come to page 43 for a moment. Para 67. The minor note to Rule 15 states that it contains rules for accessibility. Para 68, a perusal of the standards for accessibility laid down in clauses so and so in the form of the guidelines issued by the concerned ministries indicates that most of these documents do not contain mandatory or non-negotiable prescriptions. The use of the term guidelines rather than rules in most of these documents is not a mere difference in nomenclature, but is evident in the content of these documents as well. To better appreciate it, and then gives example from that, HG 2021, and then, my lord, so therefore, there has been an emphasis on the guidelines to be framed in such terms so that it's not understood as non-negotiable. Now, if my lord may come to, so para 71 again at the end. If my lord may come to Rights of Persons with Disabilities Act for a moment, because these sections are being referred to, it's important to have a look at section 40, for example. Section 40 of RPWD Act 2016 would say accessibility. The central government shall, in consultation with the Chief Commissioner, formulate rules for persons with disabilities, laying down the standards of accessibility for the physical environment, etc., including appropriate technologies and systems and other facilities and services provided to the public in urban and rural areas. Section 44, mandatory observance of accessibility norms. No establishment shall be granted permission to build any structure. So something of this sort, unless that is provided in these rules, my lord, our experience shows that they are not being complied with. Now, these UGC guidelines have still been notified under section 40. But other than that, rest of the guidelines have not even been notified. Section 46, my lord, is important. Time limit for accessibility by service providers. The service providers, whether government or private, shall provide services in accordance with the rules on accessibility formulated by the central government and under Section 40 within a period of 2 years from the date of notification of such rules. Now, my lord, Section 89 again is important, which talks about punishment for contravention of provisions of act or rules or regulations made thereunder. Any person who contravenes any of the provisions of this act or of any rule made thereunder shall for first contravention be punishable with fine which may extend to 10,000 rupees, and for any subsequent contravention with fine which shall not be less than 50,000 rupees but which may extend to 5 lakh rupees. So, my lord, unless there is a monitoring system as well as an implementation mechanism provided in these rules itself, it becomes difficult to see them being implemented. Now, my lord, in June 2024, a certain accessibility code for education institutions was notified by Department of School Education and Literacy, Ministry of Education. But so far as higher education institutions are concerned, my petition concerned with higher education institutions, colleges and universities, where many courses are still being offered online, and now with pollution, etc. So online courses has not become redundant at all, and therefore it's important to have a kind of mechanism so that people can be held to account and so that it can be properly implemented.
Have you gone through the affidavit?
Yes, ma'am.
This judgment, I've just seen the conclusions, but if your lordships will see the prayers of my learned colleague, Manat, her prayers were limited, page 19 of the writ petition. And in this petition, we have gone through the entire exercise, we framed a committee, we were directed to include them in the consultation process, take their representations, have them personally present. And after that, Manat, these guidelines.
I'm very grateful for that. I was on oxygen support when I filed this petition. So to see this outcome coming out of this is very heartening for me personally. Prayer B is important, my lord, because I did refer to, because I was concerned with whether it would get implemented properly or not. And therefore, prayer B, my lord, at page 19, issue a writ in the nature of mandamus or any other appropriate writ directing respondent number 1 and 2 to ensure that the said guidelines are strictly implemented within a period of 1 month, failing which the penalty as stipulated under Section 89 should be imposed strictly with immediate effect.
No, I think this is 21. See, the writ petition 2021.
Madam.
Today, you see, after this judgment, Rajiv Rathuri's case,
Madam.
they are obligated to frame certain norms which are non-negotiable.
Madam.
The basic
Great.
ones, you can't call it guideline.
Grateful, extremely grateful.
Chief has, I think, harmonized it with reasonable accommodation. That will be, and certain things can be expansive. So they will have to apply their mind to this.
Obliged, very obliged.
I think it has traveled beyond the prayers in the writ petition.
As I bow down, I've not seen this, the conclusions, because we completed this exercise in terms, and our affidavit was filed in September 24 itself, madam. And we carried out the exercise in this matter. And the guidelines have been framed by UGC, AICTE, NCTE and NCERT.
Mala, these guidelines are very useful,
how
very
much of the
exhaustive.
guidelines-
Please now let her also permit to.
Solicitor is addressing.
How many of these guidelines how they will have to be either changed or amended, or whether they fall within the parameters, I will have to get instructions, madam. Please, my lords.
We keep it up to 6 weeks.
Please, my lords. Would your lordship consider having this? This is a writ petition of 2005, my lords, Rajiv Rathuri. This, if your lordships are taking compliance of this, it can be taken along with this, then we'll file compliance. I'm sure union is a party here, my lords.
It's better if this is kept separate.
As my colleague likes, my lords, this is non-adversarial, but I'll have to come back now.
I'm really grateful to the learned DSG for keeping it non-adversarial and for making all these efforts, which made it possible. But it's just a little bit that's left to be done in this. Most of it has already been done.
The issues involved in the present writ petition overlap with the issues in writ petition number 6C of 243 and 243 of 2005, in which detailed directions have been issued by this court, white order dated 8th of November 2024. It will therefore be appropriate that both these matters are heard together and considered simultaneously.
I'm grateful.
The registry to tag the present matter along with writ petition number so and so. Posted in when January.
This is already listed for reporting compliance on 7th March 25. Your lordships may see para 81, the last para of the judgment.
And post the matter on 7th of March 2025 as directed by judgment and order dated 8th of November 2024 in WP number 243 of 2005.
I'm grateful.
Why should there be duplicity of proceeding? Let everything be heard together.
Obliged. Okay.
Great.
Match of 10 matters, your lordship. Services complete, pleadings are also complete, your lordship. Except for there are 2 I's that have been moved. One is for vacation of stay and the other one for intervention. In fact, this matter will take time if your lordship say have a special bench at 3:30. Otherwise, we can start off. It'll take time, your lordship. Yes, sir. But the issue involved in the matters, in all petitions are, let's say, the same itself.
My lord, there is very little in this matter, my lord. My lord, against an order of inquiry, my lord's writ petition is filed, which is dismissed. And my lord, this is a disciplinary inquiry, my lord, against candidates who are applying for, my lord, this assistant public prosecutor. And my lord's criminal prosecution was launched. My lord, these people forged their mark sheets.
No, that's not an issue.
And
If my learned friend wants to start, I'll then okay.
No, I just want to indicate what the issue is. And my lord's
it's my
forgery,
petition.
my lord's collusion with the director of prosecution. And there is allegation, my lord, even a high court judge's signature was forged, etc. in the criminal matter. Lords, thereafter,
That's
charge
against the main
sheets,
accused 1 and 2. I don't
charge
understand
sheets
that.
are filed, my lords. And my lords, against that, quashing is also dismissed. Now, my lords, based on this, the state started only an inquiry. They challenge this that the Lokayukta has no jurisdiction to start the disciplinary inquiry because under the 7.2, you can have jurisdiction only in respect of public servants. So when we applied as candidates, we were not public servants, and therefore, my lord, the inquiry sought to be scuttled at the threshold. Your lordships have time and again said this is only a initiation of the inquiry. All their defenses are available. Let them participate in the inquiry, my lord. Since 2018, my lord, nothing has moved. 6 years. Not there.
My lord,
High Court, my lord.
I am the petitioner in this matter. Let me start the lordship because actually.
Just one more thing. We were the original petitioners in whose petition, my lord, their application for stopping the disciplinary inquiry was rejected, and the High Court said that let the disciplinary inquiry go on. Against that, they file an SLP without impleading us. And they get an ex parte stay order, effectively staying that disciplinary proceedings. So therefore, the only issue before this court is really whether those disciplinary proceedings should be permitted to go on. They are facing criminal prosecution for forgery, manipulation, all kinds of malpractices that they indulged in to get themselves appointed. Public prosecution.
That's not the issue, Lord. The short issue for consideration is whether, let's say, Lokayukta can initiate proceedings against individuals, let's say, who are not public servants. That's the issue as of now. As far as the criminal proceedings are concerned, that's still pending, your lordships. We're not really disputing on that.
Well, I appear, my lords, in some of the connected matters. Well, I apologize for appearing via BC, my lord. In fact, the criminal proceedings have been allowed to go on. So, my lords, as far as we are concerned, my lords, the short question is, my lords, the disciplinary inquiry has been commenced against people who are not public servants at the time, my lords, these so-called misfeasance took place. The alleged misfeasance is, my lords, examination irregularities and malpractices. My lord, that was, my lords, prior to them becoming public servants. Under the scheme of the Karnataka Lokayukta Act, my lords, any action that is taken by the Lokayukta, suo moto or otherwise, must necessarily have
against the Shoka's notice, you go and reply. Go and reply that the proceedings are not tenable.
My lord, which we have done.
Why should the proceedings be nipped in the bud?
Articles of charges have already been framed, your lordships. We've replied an article.
Which we have done. We have done that. And despite that, the government, my lords, has in fact given the green signal for the Lokayukta to proceed. In fact, my lord, this gets worse because, my lords, the Lokayukta, my lords, which is the investigating agency and the prosecuting agency in the criminal proceedings, is the adjudicator as far as the administrative action is concerned. So, my lords, the judge, who is in fact the prosecutor and the investigator in another set of proceedings, is expected to be an impartial judge in the disciplinary inquiry, which can never happen. So these matters, my lords, may require some time, my lords. We are, of course, happy to make a start today.
Lord, in identical matters, my Lord Justice Vishwanathan sitting with Justice Maheshwari, my Lord, passed that order that all your contentions are left open. Kindly have that, just hand it over. Kindly all their contentions regarding disciplinary inquiry, etc.
Let him proceed.
Very well.
In fact, the short issue for consideration is that whether Lokayukta can initiate disciplinary proceedings for acts done by individuals, let's say, much prior to they becoming public servants. In fact, 2012, your lordships, let's say 197 posts, let's say for the post of assistant public prosecutor and assistant government leader were called for. The petitioners herein actually appeared for the written exam. They were qualified. They actually participated in the YOC. They were a part of the final select list of 197 candidates. Appointment orders were issued. Post that, in fact, let's say in 2014, your lordships, say ST Ravi, who is an unsuccessful candidate, so he challenges and he challenges, let's say, the appointment of 197, let's say, individuals, of which he makes specific allegations against accused number 1 and 2 and 23 other individuals, your lordships, wherein the present petitioners, none of them have been mentioned. Then thereafter, the trial court actually directs the Karnataka Lokayukta police for say to file a report. FR is filed, charge sheet is filed. Charge sheet is filed against only accused number 1 and 2, your lordships. Now, post that in the supplementary, let's say, charge sheet, let's say, the names of 61 individuals are included. That is where, okay, the present petitioners come in. Now, against that, your lordships, in fact, okay, the Lokayukta initiates, okay, so motu proceedings under, okay, section 7.2. My lordships may have section 7.2 as for a moment. (122) of the SLP, your lordships. That's the first SLP.
Yes.
But they must be under suspension because of the criminal thing.
They're 2020, your lordships. 2020 itself, we were suspended. Your lordships. Now, our difficulty is, okay, the criminal proceedings are pending. In fact, we have not been found guilty, say, neither in the criminal proceedings nor in the disciplinary proceedings. Disciplinary proceedings have been stayed as of now by your lordships.
Yes.
My lordships may have page 122, your lordships, for a moment. That's the first line itself. That's okay. I've extracted those provisions for there. That's okay. 7(2) of the Lokayukta Act, your lordships. In fact, subject to the provisions of the Act, an Lokayukta may investigate any action which is taken by or with the general or specific approval of any, my lordships may actually underline this, any public servant, not being chief minister, minister, member of the legislature, secretary, or a public servant. Now, my lordships may actually make a note of, okay, against the public servant. My lordships may have a look at, okay, the definition of public servant for a moment. Your lordships will find that at 118, your lordships.
One
119. In the middle of the paragraph, your lordships, let's say section, let's say 212. A person means, a public servant means a person who is or was at any point chief minister, minister, member of the legislature, government servant, chairman, member of the committee of the board. What is relevant is, okay, these three things which, in fact, these were acts, okay, which are to be alleged at a time of the written examination, where I was not a public servant at that point in time. In fact, let's say, the allegations were that, let's say, that there were malpractices during, okay, the examination. Initially, the allegations were against only accused number 1 and 2.
No, but whether the allegation is that you are the beneficiary of that malpractices. Whether the allegation is that you are beneficiary of those malpractices.
Well, no, that is yet to be proved. In fact, okay, there's nothing that...
We are asking you whether the allegation is that. We know that it is yet to be proved. It will be proved only at the end of the department.
Please, your lordships. Yes, your lordships.
We are talking about what is the allegation.
The allegation is that I was the beneficiary, your lordships. Now, in fact, your lordships would say now, so much of proceedings have been initiated, say, under section, let's say, 7.2 and, let's say, rule 20. Now, 7.2, let's say, defines, okay, that there is a prerequisite requirement for the Lokayukta to initiate proceedings. Prerequisite requirement is that I have to be a public servant. Now, I don't fall under the definition of public servant.
On the date of inquiry, you are a public servant.
On the date of employment, I was, but...
Inquiry.
And please, your lordships, but these were acts that have been alleged against me when I was not a public servant then. The requirement is that I need to be a public servant, okay, for acts done by the public servant. My lordships may have a rule 20, your lordships. Rule 20, your lordships will actually find, say, 125. Now, proceedings were initiated on 7.2 and rule 20, your lordships.
Where is rule 20? Yes.
At page 125. In fact, the requirement is that the candidate found guilty of impersonation or by submitting, say, fabricated documents or documents which have been tampered with or making statements which are incorrect or false or suppressing the material information or false or suppressing material information or using or attempting to use unfair means in an examination conduct for the purpose of recruitment or otherwise resorting to irregular or improper means which in connection with the recruitment may be in addition to rendering himself for criminal prosecution or disciplinary action. Now, in fact, your lordships may...
So who will take disciplinary action against a candidate?
My lordships...
Suppose the candidate is...
It is the government. In fact, it's the recruiting agency. In fact, Lokayukta cannot so motive actually take...
No, suppose is a candidate practicing lawyer applies for public prosecutor.
Please, lordships.
He commits some malpractice. In your case, you are selected.
Please, lordships.
Suppose she is not selected?
Well, also, in fact, in that case, say Lokayukta anyways, okay, since that person is not a public servant, there's no way that actually they can do that. It is the government itself. Government itself is recruiting.
Who will implement this rule 20 against the candidate?
It is the government itself.
Criminal prosecution is disciplinary proceeding for what?
Disciplinary proceedings, in fact, the initiation of the notice is for, let's say, dereliction of duty, Your Lordships.
In addition to rendering himself liable for prosecution
Please, Lord.
and to disciplinary action, be debarred either permanently. Three things can be done.
Please, Lord.
Criminal prosecution, disciplinary proceeding, debarment. Only question is, who is the authority if he is a selected or a purportedly selected candidate?
Please, Lordships. Now, it is the government alone could have actually initiated those proceedings here. Okay, it's a summative proceedings that have been initiated by the Lokayukta under 7.2, which has to be against the public servant itself, or an acts done or alleged to be done, okay, by a public servant itself, not by an individual. Lokayukta Act does not apply to private individuals. It has to be a government servant itself. They have to fall under the category of public servant itself. And in fact, my Lordships may have now section 8 for a moment, which actually specifically bars. In fact, my Lordships will again see page 122 itself. Matters not subject to investigation. My Lordships may have section 8A, Lordships, that if an action relates to any matter specified, in the second schedule. Now, second schedule, Your Lordships will actually find it on the next page, Your Lordships. That's at page number 123D. In fact, there's a strict bar as far as the issue relating to appointments cannot be looked into by Lokayukta. The action taken in respect to appointments, removals, or paid discipline, superannuation, or any other matters relating to the conditions of service for public servants, but not including action relating to the claims and pensions. In fact, there's a strict embargo as regards the Lokayukta actually looking into these aspects. As regards section 8A, let's say read with schedule D is concerned, Your Lordships. My Lordships, now just get back to the list of dates, Your Lordships. In fact, post initiation of proceedings in 2018, in fact, a reply is sent. Post that the Lokayukta submitted a report to the government. The government, interestingly, in fact, the inquiring agency is the Lokayukta, and actually it actually addresses those matters to be adjudicated by the Lokayukta
the
itself.
bar would be if already some action is taken in respect of appointment, removals, pay, discipline, superannuation. In that event, in such an action, the Lokayukta would not be permitted to intervene.
Now, what is under dispute is my appointment, as a public prosecutor, Your Lordship. That's the issue as of now. Now, disciplinary
Any action
proceedings
was
are
taken pursuant to that appointment by some authority.
interestingly. In fact, the initial complaint was filed against only accused 1 and 2. My name is not mentioned in the FIR, not in the first the charge sheet. Supplementary charge sheet, they include me. Now, against that, those proceedings are still parallelly going on as of now. Against that, the Lokayukta so moto initiates these proceedings. Where one, I'm not a public servant, it could have initiated, and plus there's an embargo as regards, appointments are concerned. Now, more interesting is, the state government, now assigns the work to the investigating agency itself to adjudicate the matter. Now, I'm primarily agree by, these actions of the state itself. And more so, they can't be two parallel proceedings. In fact, my Lordships may have, section 8.1D, Lordships. 8.1B, 122 itself. If a complaint that has or had any remedies by way of an appeal, revision, or any of the proceedings before the tribunal or other authority has not been availed by the same. Here, they've already availed, by filing, a private complaint, and those proceedings, are pending as of now. Charge sheet has already been filed. And as your Lordships have already
filed in criminal proceedings.
Please, Your Lordships. Those are still pending as of now. Charge sheet is filed against that. They can't, and in fact, interestingly now with two matters pending, I've been placed under suspension. None of them have actually concluded me to be guilty. Out of the 197, initially complaint was filed against the first two accused and 23 other individuals. where I actually think not even included. Post that, as per the whims and fancies, okay, they give a list of 63, against which, okay, so much proceedings are initiated and, okay, have been placed in suspension. It's been more than 6 years as of now, Lord, 4.5 years.
So for 4.5 years, you are enjoying half of the salary.
Well, in fact, they
More
were
than half.
not
It must be
one,
now
but
after some period, it must be 60%, 70%.
well, now I'm more than willing to work. In fact, there can't be greater frustration where, let's say, being qualified and being appointed as of now, that I've been not made to work. Today, let's say, all these people are at the prime of their careers as of now. Now, the very stigma itself, and plus, okay, to top it all, it's been
Stigma will come only after you are held guilty in the proceedings.
My lords, we've been suspended as of now. It's been more than 4.5 years without.
That is at your behest. Because of your petition, your suspension has continued. Otherwise, by now the inquiry would have been complete.
What stage is the trial?
Please, Lordship.
Trial, criminal trial.
Discharge applications also were filed, Lordships. It's pending hearing.
Discharge application is rejected. That's what was told.
There are 482 by, okay, accused number 1 and 2.
Rejected.
That is as regards accused number 1 and 2, Lordships.
Okay, they continue with the trial of 2000?
My Lordships, in fact, it's a complaint of 2017, Your Lordships. Complaint is 14, Your Lordships. The recruitment to say notification of 2012.
I think if we expedite that, finish it in a short time.
My Lordships may do that, but allow us to continue as of now. There's no difficulty as far as that is concerned.
Okay, you can do that.
Now, in fact, what's under challenge is, okay, they're actually seeking cancellation for the entire, okay, 197, let's say, candidates itself. If you're found guilty, yes, okay, your Lordships may punish us, but not at this stage. They can't be, let's say, pre-conviction before anything that's there, before the trial itself. Now, what we have a limited grievance is, okay, whether the Lokayukta can initiate a proceeding, let's say, against a public, against an individual for acts done, okay, who's not a public servant itself. And particularly more so in the light of, okay, where, let's say, now the government has actually assigned the work to an investigating agency to adjudicate the matter. They can't be, okay, judge in their own, say, case itself. I'll just get back to the list of dates as of now. Now, post that, okay,
Against initiation of. Rule 20 is
2019 post that I approached the tribunal, primarily challenging being agreed by 3 orders of lordship. So one is, okay, by the government recommending, okay, the Lokayukta itself, okay, to adjudicate the matter against article of charges, against which I approached the tribunal. Tribunal actually dismissed my application. Against that, I filed a writ petition. Writ petition was dismissed, where I challenged it before your lordships. Your lordships actually gave me the liberty to actually file a review. Get back to the High Court and file a review. Review is dismissed against which, but liberty is given to challenge both, okay, the order passed in the writ petition and the review, against which, I'm challenging both the orders, lordships. And against that, your lordships are pleased to actually grant stay, as far as the disciplinary proceedings are concerned.
That's 7 per.
And that's when they're hearing the matter. 7.2 deals with the SOMO. My lordships may have a look at 7.2 itself. In fact, it actually gives, let's say, the 7.2 is the, let's say, SOMO, let's say, part of the Lokayukta to initial proceedings.
So what kind of proceedings?
My lordships again look at the allegations that are made. My lordships may have.
No, is it criminal proceeding or disciplinary proceeding?
It has to be, let's say, disciplinary proceedings itself. It has to be disciplinary proceedings itself.
But that also is very local.
My lordships may actually have, let's say, page number 1.
Who is
121.
prosecuting the criminal proceeding? Which police?
It's the Lokayukta.
So going by your argument, even prosecution cannot continue because it is charges when they were candidates.
Please, the lordships. They were candidates, they were not public servants at that point in time.
There also you are raising that argument.
No, your lordship. That's an independent thing. Okay, that's under fabrication and all of it. It's not on these charges. Now I'm only aggrieved as far as the present litigation is concerned, as far as the initiation of disciplinary proceedings against me. That I'm not even contesting. I'm not even actually touching those points as of now. Those are independent, but charge sheet has already been filed. Under that's under okay, section 420, 465, 468, 471, read with 24, your lordships. Not for misconduct, your lordships. My lordships, may get back to section 7 itself. 7 to lordships, that's 122. Subject to the provisions of the Act, Lokayukta may investigate any action taken with the general or specific approval or any public servant.
Of any public servant.
Of any public servant. I am not a public servant.
On the date of action, you are a public servant.
But these are acts which were done much prior in time. What I've been alleged is an act which is much prior to becoming a public servant. My lordships may have to check the definition of action. Your lordships will find that at 118. Any action. Action means any administrative action taken by way of a decision, recommendation, or finding, or in any other manner, or includes willful failure or omission of any of the expressions relating to an action constituted accordingly. It has to be in my official capacity. My lordships may have now the next definition, that's 2.2. Allegation in relation to a public servant includes any affirmation that a public servant has abused his position as a public servant. Now, if you actually were to look into 7.2, read with section 2.1 and 2.2.
This is conduct unbecoming of a public servant. Who are now a public servant.
Please, lordships.
There is a conduct which has come.
See also, such a public servant is guilty of corruption, favoritism, nepotism, or lack of integrity in his capacity as such public servant.
As a public servant, I was not a public servant then. And in fact,
So
I'm not guilty of corruption. I've not been held guilty as corruption. In fact,
a lack of integrity
my lordship,
at the time of your appearance in the examination and that misfeasance.
For that, I have to be found guilty. I have not been found guilty as of now. No court has actually found me guilty. The threshold is much more higher. Now, as regards a public servant is different to the one that's of a private individual. Now these were acts done as a private individual. None of these acts were in the capacity of a public servant or any administrative action that is there. In fact, reading of section 7.2 read with section 2.1 and 2.2 makes it amply clear that these are all acts which in their official capacity itself. The Lokayukta would have the power to initiate proceedings under 7.2. And more shocking is that where the adjudicating authority itself, the investigating agency itself now is the adjudicating authority. It's against principles of natural justice. And in fact, as regards even section 8 also, that there is a strict embargo as regards if there are any other criminal proceedings under 8B, you can't actually initiate these proceedings.
You got the copy of the act. So
I have
typed copies are dangerous.
My lordships, may I have a look at this? There's only one copy, Lordship, so I'll give the other.
There is another copy.
Guru.
No copies.
The same one.
Yes, yes.
My Lordship have the second copy. Other relevant sections have been marked also. We did them, marked time. Hey, put up. My Lordship might just have a look at 4 sections. That's okay. One is 7.2, read with okay, section 2.2.2, 2.1.2.2. And 8A read with let's say the second schedule, which bars as far as let's say appointments are concerned. Yes, we have to. You may not. Okay, ma'am. The last page. I think so. It's already here. It's there in the paper. It is there.
Not complete. Because we just have one copy.
What is it? Rule 20.
One is not.
Just flag it up. Hmm? Just flag it up.
So, if you not, if it is not selected, I will, complete.
Now, one more answer to Justice Vishwanathan's query as to say who would be authority if the candidate is not selected. In fact, now proceedings have been initiated under let's say section 7.2 and rule 20. My Lordship may have a look at rule 20, which says that it's the government.
If the candidate is not selected.
If the candidate is not selected, then it would be the government.
The proceedings are not under the Lokayukta Act. The proceedings are under Rule 14A of the Karnataka Civil Services Rules. Learned friend should address that, my lord. The order which is challenged is under Rule 14A. That order, my lord, lordships will find at page 167 of the SLP paper book. 160 at page, my lord. Order starts at 172 at page 176. This is the order of the state government referring the matter to Lokayukta for an inquiry, for a disciplinary inquiry. This is challenged. Kindly have a look at 176 with reference to the preamble and report submitted by the Upalokayukta under 12.3. It is hereby accepted. So the government, my lord, looking at the nature of allegations, applying its mind, then passes this order. It is hereby accepted in order to initiate disciplinary proceedings under 14A. Now 14A merely says, my lord, that the Lokayukta will be an inquiry officer. He will inquire, submit the report to the state government, and the state government will then proceed to take action in accordance with Rule 11A. Yes, my lord. Yes, my lord.
To be traced to a provision in the Lokayukta Act.
That is under Rule 14A, my lord.
No,
It is started under 7.2.
two capital A, the non-obstante clause in 7. Come to 7.2A.
But 7.2 is the preliminary inquiry.
2A.
Yes. Yes.
Notwithstanding anything contained, subsection 1
Anything
and
contained in subsection 1 and subsection 2.
Lokayukta or Upalok.
Lokayukta may investigate any action
Any action taken by or with the general
or
or
with the
specific
general-
approval of a public servant. That is,
if it is
he
referred
says, suppose he has
2-1.
given an opinion to close a criminal case,
to. Yes,
taken in his capacity as an APP,
yes, bro.
not, something which happened before. That may be subject matter of an inquiry under the disciplinary rules.
That is all, Manoj. That is what we are saying, Manoj.
No, he's saying, why are you bringing in the Lokayukta?
No, 14A says so. Kindly have a look at that rule. 14A has not been plagiarized. There is no other procedure. Kindly have rule 14A.
14A is where?
But the entire
Civil service
proceedings.
So you are
terminate
saying
out of the
Lokayukta is
sum of the
only a
proceedings that's there.
delegate of an inquiry officer.
Yes, my lord. Now kindly see this. The rule procedure in this case is entrusted to the Lokayukta. The provisions of sub-rule 2 shall, notwithstanding anything contained in rule 9, 11A and 13, be applicable for the purpose of proceeding against government servants whose alleged misconduct has been investigated into the Lokayukta or an Upalokayukta, either under the provisions of the Lokayukta Act or on a reference from the government, or where alleged offences against them punishable under the PC Act or the 1988 Act have been investigated. So, my lord, 4 or 5, my lord's conditions. One, my lord, that there is already an investigation by the Lokayukta, Upalokayukta, or there is a criminal case against them. Then what happens, my lord? The Lokayukta or Upalokayukta, the IGP, the disciplinary proceedings shall be taken. He shall forward the record of the investigation along with the recommendation of the government. And the government, after examining such record, may either direct an inquiry.
See the answer, where they are already being.
How would that apply a lot? It's against whom? A, B.
1 second. Lord, then just one more provision. After the inquiry, the Lokayukta conducts an inquiry. Report is then submitted back to the government.
To the government, the final decision is taken by the government.
My lord.
Only as a delegate, like any inquiry officer is a delegate. So,
But where did the very genesis of the issue start off?
because Lokayukta has already initiated proceedings for those kind of categories which come under 1. For 2, they say Lokayukta will do it, so they will be in possession of all the material. And then it will come as for action taken, then the normal disciplinary route will follow. They may agree, disagree, notice, differing, everything will happen.
The genesis itself actually starts with the suo motu proceedings under 7.2 itself. Now, the very genesis itself is wrong. Our primary line of argument is that, Your Lordship. In fact, it cannot be, it has to be against the public servant itself. If a complaint.
See, here Lokayukta is brought in as anybody can be inquiry officer. Here Lokayukta has been designated as the inquiry officer. Receive the report.
I am not disputing that. I am not for a moment disputing any of those powers. In fact, they've already filed charge sheet as far as the other proceedings are concerned.
Thank you, Mr. Dismissed.
My lord, could I just make 2 submissions, my lord, because I appear, my lords, in 3 of these matters.
Yes.
My lord, the simple issue, my lords, is we say that there is no jurisdictional fact for a disciplinary inquiry to be commenced. My lords, the jurisdictional fact must be an administrative action. My lord, there is no administrative action, my lords, which has been alleged against me, my lords, for the act of misfeasance. The act of misfeasance that is alleged against me is an act, my lords, that is alleged to have taken place before I entered public service. Of course, there is no difficulty. That can be the subject.
Mr. Duli has already argued.
My lord, could I just show, my lords, 2, my lord?
Pramod, you are otherwise right, but for 14A,
yes,
which for certain categories of matters already investigated by the Lokayukta, including in a criminal case,
Yes.
Lokayukta is designated as the inquiring authority
Yes.
for bringing some kind of uniformity to the extent of inquiry. Then the
Yes.
report comes and the normal track follows. To that extent, there is a jurisdictional fact.
I'm so grateful, Manoj. Could I just point out, Manoj, how, Manoj, we would be prejudiced by it? The Lokayukta is the investigating authority and the prosecuting authority as far as the criminal investigation is concerned. Manoj, and if they, Manoj, are put in charge of the inquiry, which they have been by virtue of page 173, Manoj, what kind of justice can I expect? Because, Manoj, the adjudicator is in fact the investigator and the prosecutor as far as the criminal proceedings are concerned. Would it not benefit them for them, Manoj, to reach the conclusion that I have in fact, Manoj, committed a misconduct? But Manoj, that is, Manoj, going much further. The issue is
apprehending too many things.
Manoj, could I just, Manoj, just 2 points which I want to make, Manoj. The fact is, Manoj, could I just very, very quickly, Manoj, take Manoj to the genesis of this. The genesis of this, Manoj, is a report by the Upalokayukta under section 7.3. Section 7.3 necessarily must be in respect of an administrative action. Manoj, could I just make that point? Manoj, that section 7 is extracted at page 21. Manoj, 7.2, which your lordships have seen, is the Upalokayukta may investigate any action which is taken by a public servant. The action, Malad, is defined in section 2, Malad, as, Malad, that is at page 118, means an administrative action.
That has also been shown to us by Mr. Nalli.
Yes, Malad, the action must necessarily be an administrative action. Malad, there is no administrative action of which, Malad, I have been accused of any kind of misfeasance. Kindly see page 118. Administrative action taken by way of decision, recommendation, or finding, or in any other manner, and includes willful failure. So, Malad, as your lordships have kindly put it to my learned colleague, Malad, if, for example, they have taken a wrong decision to close a prosecution, or if there is an act of bribery, or any of those aspects, Malad, those necessarily relate to administrative actions. If, my lords, there is any administrative action in respect of which I have committed a misfeasance, of course, there can be an inquiry under section 7. But Manoj, Rule 20, so Manoj, the issue is this. Rule 20 is not a charging section in that sense because it does not create an offense. What it does is it prescribes the consequences of me being held guilty in a criminal proceeding. But then what it does is it permits that there can be multiple consequences that can be visited upon me. I can be held guilty in a criminal prosecution. If I'm held guilty, then I can lose my job. I can be debarred from appearing again in a public examination. Those are the consequences. Rule 20 does not create an offense. It does not prescribe any kind of misconduct for which I can, any kind of departmental inquiry can be commenced against me. So Rule 20 does not apply. Section 7 does not apply because Section 7 again relates to an administrative action. But then in respect of what is the charge against me? The first charge that was made against me, Manoj, was dereliction of duty. Manoj, dereliction of duty presupposes that, Manoj, I have taken an action or I've been guilty of inaction whilst I was a public servant. But an act which...
He also is for one of the petitioners, Your Lordship.
No, you are for
Manoj, I appear, Manoj, in 3 of these matters, 21.6, 21.7 and 21.9.
For the selected candidates or for the...
selected candidates, Manoj, selected candidates, selected candidates. So, Manoj, of course, Manoj, there is a criminal proceeding against me. If I am held guilty, Manoj, Rule 20 will apply with all force. So in addition to me being held criminally guilty, Manoj, I will lose my job. I will be debarred from public employment again. There is no difficulty about that. Manoj, that, of course, the government is entitled to do. But today, to commence a disciplinary inquiry premised on, Manoj's administrative misfeasance, when I was not even an administrator, I was not a public servant.
Thank you.
If I may,
Thank you.
one request, Lordships, at least till the disciplinary proceedings are going on, some empathy from this court to say, let us at least continue. Anyways, okay, they're paying us 50% of the salary. Until such time.
Empathy.
Well, Lordships, now see, I've not been held guilty as of now. If I'm found guilty, yes, okay, suspension would be right. But as of now, at this point in time, say at least okay, now neither okay, now there are two proceedings that are running against me. Charge sheet is filed in the other case. As far as the disciplinary proceedings are concerned, let it continue. There's no issue with that.
For last so many years, you are getting so much amount without doing any work, and you want it to be continued.
Only 20. I've served, Your Lordship. In fact, let's say the appointment is of 2006. 14 posts that we've been working. It's only in 2020. It's only in 2020 we were suspended, Your Lordships. There's one order of the High Court itself which says that, in fact, which is also challenged by the state, which one SLP which is filed by the state, where High Court specifically says that until such thing, until the proceedings are on, they take the services.
Where is that?
My Lordships may have a look at that order.
Grateful.
Option or direction to take the services?
It says, my lord, in that view of the matter, we direct the first respondent to consider revocation of the suspension order and pass appropriate orders within 15 days from the receipt of the copy of the order. And also, and says that the services of the petitioners may be utilized to the respondents or otherwise the fact remains that the subsistence allowance paid to the government servants would remain under page 5.
Page 4.
So what have you done?
They have not taken, they challenge it. They challenge it before this court. Until such time, my Lordships may allow us to actually continue. The moment we are found guilty, they have every right to do that.
How can it be with a criminal case pending as a prosecutor? Can you prosecute others?
Lordships on 14th October 22 were of state risk election. This SLP needs to be allowed.
Law mandates that each accused is entitled to be presumed innocent until found guilty.
8 and 9 at page 5.
In this matter alone?
In this matter alone.
21 point.
And all others are dismissed.
How can you, Mr. Nooli, you want to prosecute people?
Well, but we have not been found guilty. I can still understand, okay, there is a conviction against me. None of those proceedings have culminated. It is almost a pre-conviction, Your Lordship.
Yes, thank you.
Great.
Deeply obliged, my lords. Obliged.
Number my lord 30 and 30.1 my lord. My lord, before the High Court, my lord, the matter is listed on 5th November. Other side is it. I have no objection, but before 5th November, my lord, because the
High Court is not?
There are two kinds of orders passed by. We have an order passed by 9th of August.
that is on different footing, my lord. My case is on different footing, my lord. My case has been final up to this Sunday.
Why we'll put it on some Tuesday? Why? What is the difficulty?
Saying that before 5th November, my lord, any date, my lord. Because
Before 5th November?
5th December, I am sorry, my lord. 5th December, my lord. I am very sad. Before 5th December.
Now, irrigation is also long.
Yes, Mr. Kaul. Put it on some Monday week.
Yes, my lord. No, it's item 30. Sorry, I wasn't unmuted. It's item 30, my lord. There is some urgency in this matter for the state of Gujarat. Despite your lordship's order, my lords, the review proceedings are not going on. In another writ which had come before your lordships had specifically said that whatever orders have been passed cannot be construed to mean that the review proceedings cannot be heard. But that was a separate writ petition where an order passed in this SLP was shown. So we had gone ahead and to say that the review should be heard. It's not being heard in the exchequer, and the stakes are so high for the state of Gujarat because despite clear judgments in our favor, in the case of Ad hoc Teachers Association, the same principle is being applied to contractual teachers, which has been held to be non-applicable at all, my lords.
Okay, we'll have it Monday week.
Let's item very grateful, my lords. Very grateful.
Please.
I think 35 laws in it relates to NEET PG 2024.
Tomorrow it will go on next Tuesday now.
Well, it's item 22 minutes. Item 22 minutes.
Yes.
The very next item. My lords, may can have next Tuesday at the top of the board. We've been suffering in interim orders last 1.5 years.
Next Tuesday.
But 25 may also come. 25 may also come next Tuesday.
chapter of 7, third of the 7. Till date, there is no High Court orders which are in favor of, contrary to what the Supreme Court is. Patna not challenged, Kerala not challenged, Tripura not challenged. Those orders continue to be in force. Yes, all them are now. How about Punjab? Punjab is pending. There is subject. Odisha is also subject. In Odisha. Bihar is not challenged.
No, the judgments, final ones are Punjab, Assam, Tripura, Kerala and Patna.
Yes.
All the others are still pending in the High Court. But it will be decided on the basis of this.
No, but yes.
Already decided because
There's one more part to this.
He is obviously given a foundation of Patna and Tripura around. So which High Court will be bold enough to take a decision?
There's one more thing that we had done, which we have stated in one of the MAs already. There were 2 writ petitions pending in Patna and Delhi, to which we filed a transfer petition in Supreme Court, saying that this judgment will not really apply to us because this helped with only, this gave benefit, or this reserved thing only for insolvency. So therefore, since the question of law is same, please transfer these things to Supreme Court. Justice Oak held, and he issued notice granted stay. That will also ultimately follow this.
They have to come out.
If it happens. As of now, it is with Justice Oak, then it got transferred to this court.
It's too my plate.
We have put proof that all of them were in service. Somewhere down the line, there seems to be confusion. There seems to be a confusion in their mind that it was only for in service, but all of us are in service. There is no question of not being in service. In fact, we have put proof. So that's the precondition for any person taken in ION service.
What do you say? Wait, please, Manoj.
just say that there are 9 MBAs. I have been in the enlistments for 100 candidates who have not been participated in the study.
So your lordships are well aware of what transpired. Now it's this review petition. While they're not all parties, it covers and will have an impact on about 12 lakh teachers who were in service at the time that the RT Act section was amended.
So that is what we have held that that special 18 months course was for protecting the teachers who are already in service.
Correct. So
But it can't be made applicable for future employments. That's what we.
Yes, so if I may, the idea, Manoj, was simply this, that in curriculum and in everything else, the program is exactly the same, including the internship period. It's a 24-month program.
No, it's a 18-month.
No, the program that has to be followed as has been laid down by NCTE is a 24-month program. Now, the relaxation that was provided to ensure that they fall within the timeline because section 27 was amended and the proviso was included, which allowed those in service to complete by 31st March 2019, which required it to be completed in less than 24 months. So that's why the relaxation was brought in so that they will finish in 18 months. Now, what has happened is, Malons, that 18-month period is being treated as equivalent not by the Uttarakhand High Court. Your Lordship judgment says that the High Court couldn't have gone in and created an equivalence. That perhaps is not what I think would be borne out from the record, because there were actually an expert committee that had been set up by NCTE. All this took place on directions which were